The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. All right, we are prepared to hear argument in United States v. Sutton, and let's see, Ms. Renee, we'd be pleased to hear from you.
Good morning. May it please the court, I am Patricia Renee, appearing on behalf of Ms. Margaret Ann Sutton, who is appealing her convictions and sentence in this case. We'll start out with, and these are, of course, various drug and firearm convictions that she suffered. Beginning with the conspiracy, as the court is aware, it requires a knowing and voluntary participation because indeed the government did establish a drug conspiracy involving Mr. Andrews, West, Moore, a multitude of people. But Ms. Sutton is not one of those people. What we have regarding Ms. Sutton is essentially a simple single buyer-seller transaction between she and Moore. And this is only because Moore, who is in a conspiratorial relationship with Mr. Andrews, was not able to reach him. And in fact, they tried to consummate this deal the day before. She couldn't reach him. She's calling Sutton. Sutton's not responding because she's not part of that. The following day, when the transaction occurred on April 21st, she's again calling. Sutton finally responds to her and says, okay, come over, I have it. And Moore goes over, the transaction occurs. I think that is what's, obviously that's just one single transaction. I think that what's particularly...
Your position is that a jury could not conclude from that? I mean, we can talk about the trip to California to supply drugs and all these things, but even if that was all we had, help me understand why we wouldn't understand that was, or a jury could conclude that that's evidence that she had agreed with Mr. Andres to distribute narcotics. Well, like the basic premise of the conspiracy.
Right, so that there's no evidence to support an agreement between she and Mr. Andres. And I think that what's most telling...
That's because there's no evidence that I don't even understand that. So it was Mr. Andres's, at least allegedly, the record might show, it was his drugs, right?
Correct.
And your client distributed it. And is your argument that she stole it?
It's my argument that she distributed drugs to Ms. Moore, but they were not the drugs that belonged to Mr. Andres.
They were her own drugs.
I don't know whose drugs they were, but I think that what's particular...
And your point is a jury could not conclude otherwise.
A jury could not conclude otherwise for two reasons. One, the fact that Ms. Sutton had to get Ms. Moore to stop and buy scales in order to weigh the product for her, I think is pretty powerful evidence that she's not involved in a conspiracy to distribute when there are multiple scales inside of Mr. Andrews' home where Ms. Sutton happened to be. So I think that's pretty powerful evidence of lack of a conspiracy. Also, Ms. Moore...
Why? Help me understand that. Why is that evidence that there's not a conspiracy? She doesn't know everything that's in the house, and therefore she reached no agreement to distribute the drugs?
It's not just everything that's in the house. The scales, that's the tool of the trade. And so if you're a part of this trade, you would know where your tools are. And so, and again, Ms. Moore testified that Sutton measured the drugs out of a black bag. The evidence that was found in the house in the clothes hamper, there was no black bag. There was a
I
crown.
thought there was some evidence that they had traveled. I know you contend basically that this was a romantic relationship and not a conspiratorial relationship, but they drove to California together, I thought, to consummate a transaction, and then when Mr. Andres was ill-disposed, I guess he may have been sleeping or whatever, the transaction was executed by M.S. Sutton, and she was at the premises a good deal, and she was a distributor. I think there may have been some evidence before the district judge, this was a bench trial, that she, as a distributor, which was what she started off as, made a good deal of money. I think the figure that was thrown around that she was making for Mr. Andres $50,000 a month.
Well,
This was a bench trial, and that was before the district judge. So when you put this kind of evidence together, it transcends buyer-seller relationships or romantic relationships or what have you, and it gets to the point that it's not buyer-seller, it's not romantic, it's a step up, which is co-conspirators in a drug distribution scheme.
So to address specifically regarding that, there is a lot of evidence that the Commonwealth introduced, and the evidence, and it's all the government. It's all the government's evidence, and the evidence, most of it is conflicting, is contradictory. That's their evidence, which makes the evidence overall equivocal. For example, Wes testifies, as the court indicated, that Sutton distributed drugs on direct examination. On cross-examination, she said that she characterized Sutton's presence in the home as that of a customer. So this is conflicting evidence from the government. So
Isn't it the job of the trier of fact to resolve the conflicts in the evidence?
well, to a certain extent. But if the trier of fact is going to take all the evidence, pour it into a sieve, and sift out all of the evidence that undermines a person's guilt and only save the little clumps and pieces that support a conviction, that overall is equivocal evidence, and also which is not substantial evidence.
Say that last part again. So if they put the evidence in and they only take out what they believe and they discard the things that they don't believe, why is that equivocal?
It's a
It's
difference.
like the opposite of equivocal.
It's a difference when you have defense evidence that's in conflict with the government's evidence. But when the government's own evidence from their own witnesses that the trier of fact is asked to believe is giving conflicting evidence, the witnesses contradict them themselves within the same testimony. For instance, Wes, if she says on the one hand...
Is there any case or suggestion that we've had that a witness who conflicts themselves cannot be believed at all? I mean, you've done enough of these trials to realize that, like, at least with a competent cross-examiner, everybody has some degree of inconsistency. Right? That's like the nature of testimony.
We have to bear in mind what the legal standard is, which is substantial evidence. And if evidence is equivocal...
Taking evidence in the light most favorable to the government.
Correct. And there has to be substantial evidence. So to take that perfect example, if Wes on the one hand says Sutton is distributing drugs, then on the other hand she says, no, I characterize her as a mere customer, you have two competing statements there by the same witness of the
Those aren't
government.
inconsistent statements, right? I mean, those are not inconsistent statements. I mean, you can roll your eyes at me about it, but
Oh, I'm
those
sorry.
are not,
I didn't mean to
those
do
are not
that.
inconsistent statements, right? You can both be involved in the distribution and be a customer. In fact, like oftentimes in drug conspiracies, that's a common occurrence.
That was not the testimony. That can occur, yes, but that was not the testimony. On direct, she stated that she was helping to distribute. On cross, when pressed on it, she backed away from the statement and changed her testimony into something else. Oh, she was a mere
What's the
customer.
JA site where you say that she disregarded her prior testimony and said that she was wrong?
JA 245. And as far as the trip to California, the evidence showed that Andrews had made multiple trips to California with his drug conspiracy partners. On this one occasion, right after Sutton had started a romantic relationship with him, and keep in mind, that was only a 3-week period of time. And Andrews had hired Olive and her boyfriend to drive him to California. Sutton was nowhere around. She was in Tennessee. They stopped in Tennessee to pick her
I'm
up.
looking at JA 245. Can you help me understand where it is that she says, when I said that she was a distributor of drugs, I was wrong. Instead, she's merely, which is the word you used, she's merely a user or a customer.
Yes, I'm interpreting her statement. In fact, my point is, she didn't say, oh, in addition to being a
You
user.
just said that what she said was that she backed away from her prior statement and she said that she was a mere customer. And so if you're representing that to the court, what I want to understand is, where is it?
Judge, on the government's case, I will try to find that specific.
It's not on 245 though, right? We can agree on that?
Okay, well, then I have the wrong page number. I'll have to look in my brief. But again, this trip across country is a single trip. She was in a new romantic relationship with him. That's not uncommon that she would go take a trip across country with him. But when they got to, and she didn't drive with them, she was in Tennessee, as I stated, and when they got there, they flew there.
Wouldn't it be for the trier of fact to determine the purpose of the trip?
Well, yes, but it has to be in the context of all of the facts and circumstances. And in the context of these facts and circumstances, a new romantic relationship, he's going to take a trip to California, she goes with him.
What about the money that she made for him as a result of her, as a result of that collaboration in a distribution scheme? I mean, she made a good deal of money for Mr. Andres, did she not?
She was only involved with him for 3 weeks. The testimony was that that had happened sometime in March or April. West moved out at the end of March, and there's no evidence that Sutton was on the scene before then, so it wasn't even a full month. I'm sure the fact finder can sift through the evidence and decide to believe the evidence that points to a person's guilt and disregard that points to their innocence. But that's at this stage. At the trial court stage, when the trier of fact is considering all of the evidence has to be substantial. It has to be a substantial amount of evidence. And we just really don't have this. We have someone.
Mr. Andres was indisposed for whatever reason, wasn't she the one that executed the drug transaction?
Yes, a single buyer-seller transaction, she did indeed.
At a certain point, these cumulative bits of evidence mount up, do they not?
The standard is substantial. If this court believes that these individual little bits of evidence of her relationship with him at that house during a 3-week period of time when Mr. Andrews has been dealing drugs since 2010 and had been dealing drugs with West that he had been in a relationship with for 8 to 10 years.
I know the thread that runs through your case and the general thrust of the case is that this was a romantic relationship, and that runs through a lot of the different assignments of error.
And there's no evidence that she lived at the house?
But it was that central question that we have a trier of factor to resolve. And here, I think, and there's a good bit of evidence to support it, but the trier of fact simply found that she was a very valuable partner in this whole distribution scheme. I mean, the drugs were lying around and in plain view and on the premises. They were in the living room, they were in the master bedroom, the firearms were within some proximity to the drugs. She was in a position to know a great deal about what Mr. Andres was up to. This is not an innocent association, because the evidence of it was strewn throughout the house.
Well, respectfully, all of the evidence was found inside of Mr. Andrews' bedroom, inside of a clothes hamper, and 2 of the 3 firearms were on the dresser. There was a firearm in the living room, and presumably it was in the living room area where Ms. Sutton distributed the drugs to Moore. So, and there's no evidence that Ms. Sutton was ever in his bedroom. There are no personal items of hers. Her clothes are not in the hamper where his drugs were found. They're not in the closet. There's no evidence that she was ever in his bedroom. And it requires more than her knowledge of his criminal activity. She has to be a voluntary participant in it. And that's the part where there's no evidence that she was a voluntary participant other than the single mere buyer-seller relationship where she engaged with Ms. Moore.
Thank you very much, Judge Rushing. Do you have any questions we appreciate it?
Okay. And if I may address maybe some of the other issues on my rebuttal, even though I haven't brought them up now.
Some time on rebuttal. But I'm not saying your arguments aren't good ones. They are, but you have to persuade the trier of fact that they should prevail. That's what's hard about it. But we'll look forward to hearing from you on rebuttal, okay?
Okay, thank you.
Ms. Picara, we're pleased to hear from you.
May it please the court, Jacqueline Bashara for the United States. I'd like to start.
One question I had for you on the premises conviction. You seem to argue that Ms. Sutton maintained the premises in terms of the drug distribution scheme. And I was sort of puzzled as to why you didn't put more emphasis upon another verb in that statute, which was to use, because it seems to me that I think this was in line with the Second Circuit. Those verbs are written in the disjunctive, and so any one of them would suffice for a conviction. And it seemed to me that your burden of proof would be, significantly less under the word use than it would be under the verb maintain. There's all sorts of evidence of use. not sure that it makes a difference because the offense of conviction can be based on any number of bases as long as you prove one of them. But why wasn't your argument in this brief before us more one of use than of maintenance?
Your Honor, we did argue at page 36 of our brief. It's not, I guess, the thrust of our argument, but we did argue that a reasonable fact finder could
Can you
infer.
speak up a little for me? I want to be sure.
Yes, Judge Wilkinson, can you hear me all right?
Yeah, that's
Okay.
great.
At page 36, we did argue that a reasonable fact finder could find that she used or maintained the premises. We did focus on maintain because that's where all of the court's case law has focused, is on the maintaining verb. I believe that the Fifth Circuit's decision in Santiago might be the first Court of Appeals decision to really construe the use provision. But we did also we charge in the alternative in the indictment, that's at JA 46, all of the verbs, we charged those. And we did argue in closing to the district court as the fact finder, that's at JA 543, that any of these verbs would establish our burden of proof here.
So you made that argument in terms of use below.
We did.
So I was just surprised that there wasn't more emphasis on that in the appellate brief, because you do agree that, I mean, didn't the Second Circuit go on a use theory?
The Fifth Circuit in Santiago, I believe? Or
No,
maybe Your Honor is referring to a court.
It was enough to prove use.
Yes, and certainly this is enough to prove use, whether or not the evidence supported the inference that she lived there. Obviously, the government's position is that it was enough to infer that she lived there. But even if she didn't live there, that means that she is directing someone to go to this house for the purpose of doing a drug deal. That's classically what the statute is intended to capture.
Well, she can be convicted under the statute. The statute seems to indicate that there was some utilization of the premises in some form.
Yes.
And there are a lot of it. You don't have to be a spouse. You don't even have to be a house guest. As long as you utilize the premises in some way. And the evidence is that the conspiracy operated out of the premises. And so it would be odd to say that the statutory elements of a premises conviction were not met when the operation centered when the conspiracy centered its operation around the premises.
Yes, Your Honor, and there is evidence that she is, I think in the words of Davis, that she's on the scene even before the controlled buy occurs. Both, I'm
I
sorry.
get that it might not be totally implicated here, but we could imagine the word use with sort of a fairly expansive reading, such that, you know, if my law clerk Will here, he's involved in a drug distribution business, and he happens to be running it out of, like, this courthouse. This is hypothetical, I think. That
I hope.
that he would be using this courthouse in some colloquial sense, right? Like, or you know, if he instead ran it out of a 7-Eleven or like literally anywhere he was, you know, if he's in a tent, right? Whatever it is, he's using whatever location he's in. Is that colloquial sense right? I mean, can we interpret it so broadly that he would be guilty of using the federal courthouse in my hypothetical as a drug premises? I mean, that seems like an odd reading, but I think you could read the word use that way, or do you think there's a limitation that we ought to include?
So you need to look at the two mens rea elements of the statute, right? We have knowing. I don't know if Your Honor might be getting at kind of concerned that Your Honors might be implicated as aiders and abettors or something in this use of the
pretty
courthouse.
comfortable. I'm good.
Okay, all right. I don't know. I'm trying.
He's going to jail, but I'm not. Let's start with that premise, right?
Okay, we also have,
Saying, like,
well,
talk about a use
Yes.
of like a federal courthouse.
right. So then we go to the for the purpose of requirement, and every court to have looked at this has said, okay, the drug-related purpose has to be a specific purpose, but it doesn't have to be the sole purpose. And then we weigh kind of like how significant of a purpose is it. And so where courts have not sustained convictions,
Why do we
it's
weigh-
because
Where do I get the weighing from?
Well,
So, like, help me understand, like, why I get the weighing, because obviously there are lots of us that use this courthouse for lots of different reasons, right? But Will might be using it, like, predominantly for his drug business? And, like,
Yes.
am I weighing just his use, or am I weighing all of our uses?
So where courts have looked at this in the context of residential premises, right? They've looked at, okay, the primary purpose was residential and the distribution of drugs was maybe incidental. Those cases all deal with a particular individual, so I understand that's sort of distinguishable, but that's why I would suggest that I hope the primary purpose of this location is to do the court's business, not to do drug dealing.
I think that the question, I mean, you certainly don't want use to be established simply from the fact that someone makes one visit and moves out. But I think use would have to be of a regular sort and of enough significance to constitute utilization in some way. And the question of, I'm not sure that we can sketch it all as to what use does and does not matter on appeal, but it seems to me that you rely on your trial judges here to decide when the use is of sufficiently substantial nature to constitute use of the premises. And here I say the premises was not just something that she visited upon an occasional basis to pick up drugs. It was the center of the whole operation.
Yes, Your Honor.
And it was the operational nerve center of it. So if, under these facts, if that isn't used, then the verb that Congress included serves no purpose. You see what I'm saying?
Yes, we agree. And of course, the other evidence that is recovered from the house supports that that's what the house was being used for, right? We've got the baggies for packaging drugs. We've got the scales, hundreds of thousands of dollars worth of meth in the house. That's all consistent with.
Yeah, you go even further and say that the regularity of her contact and
Yes.
and the profitability of it and the extensive time that she spent and all the rest, it rises to the level of maintenance as well. All I'm suggesting to you is that Congress included the verb use for a reason, and that was that it did not want full-scale maintenance necessarily to be a precondition for or serve as the sole element of conviction.
Yes, we know that because Congress expanded the statute to add these verbs in 2003. And it's noticeably different from the guideline enhancement, which you all, I suspect, might be familiar with as well, which only applies to maintaining a drug premises. This is notably broader.
Can I ask you
Yes.
about a different charge? The possession with intent to distribute the marijuana. Your brief kind of lumped everything in the house together, and because you had a lot to cover, but I wanted to get your theory on how she's accountable for the marijuana more particularly, if it's conspiratorial or if it's an argument that she actually possessed it herself.
I think there's enough to find constructive possession because we start with the trip to California. We know she went with Andres, where he gets both the meth and the marijuana. He brings it back to the hotel. And Olub testified it's a lot of marijuana, and he shows it to them. And then on the drive back from California to Virginia, the puzzle box that's pretty kind of a centerpiece of this case, is sitting in the back of the truck. And then when officers execute the search warrant, they find almost 10 pounds of marijuana. It's in the same puzzle box, and it's sitting adjacent to the bathroom door in such a way, I think the testimony was basically you would trip over it if you weren't watching where you were going. So that's enough to infer that she knew about the marijuana and kind of had control over it. But certainly the court could affirm this conviction based on co-conspirator liability under Pinkerton.
I mean, the puzzle box, it's such a great law school hypothetical, right? It's someone has created a box just for this one guy, and only this one guy knows how to open the box. The testimony is no one else knows how to open the puzzle box. And she's never selling the marijuana. She's, so she may be constructively possessing it. Is she constructively possessing it with intent to distribute? Because she can't access it. I was looking for a picture of the puzzle box in the record. I didn't see one, just because I'm curious. But
It is in the record. It's not in the JA,
Not in the
but we
JA.
did submit it as an exhibit at trial, and I'm happy to supplement if you want to see the picture of it.
no. And I'm not saying you can't get there. You might have you might be able to get there anyway. But I wondered if you were relying on some sort of conspiratorial assignment of responsibility to her, or if you had a more direct route that you were pushing.
Our brief focuses on direct liability. We did argue Pinkerton to the district court in closing, so the court could affirm on either basis.
Do you accept the premise of Judge Rushing's question that the trier of fact could only find that only he could open the box? I mean, it wasn't totally clear to me, right? I get that there was some suggestion that he was the only one that could open the puzzle box, but are we required to take that? I mean, obviously we don't have findings of fact here, but if we construe the evidence in the light most favorable to the government, is that a fact that we would have to accept in the premise, or is that an unknown?
It's unknown. There is no testimony as to whether Sutton knew or didn't know how to open the puzzle box. You could infer from the fact that they're in this romantic relationship and she goes and retrieves the meth and weighs it out that,
There is
she
a
might have.
suggestion that only he can open it, and where does that come from, and how do we discount that?
There was testimony, basically, as Judge Rushing alluded to, that he had it created for this special purpose, for storing his drugs. But to the extent that Sutton is involved in this conspiracy, which, viewing the evidence cumulatively and in the light most favorable to the government, presumably she would be in on this other purpose of distributing marijuana. And also the court can infer, just given the volume of marijuana, right? Agent Faddis testified this is definitely a distribution quantity.
Under a reasonable foreseeability standard. Is that correct?
Yes, the court can affirm based on Pinkerton also.
Should be based on a reasonable foreseeability?
It's reasonable, foreseeable, and in furtherance of the conspiracy, yes.
And your theory is that it was certainly reasonably foreseeable because she knew everything that was going on.
Yes.
There wasn't much that occurred in his activities that wasn't reasonably foreseeable.
Yes.
I mean, there wasn't much that went on there that she didn't know about.
We agree with that characterization, Your Honor. I would like to respond to Judge Richardson. Maybe you already found this JA citation about the drug customer testimony, whether West kind of went back.
57, can you explain?
Yeah,
Just
we disagree with that characterization. If you start reading on JA 256, the testimony is, so Sutton's counsel asks West, how often did you see Sutton over at Danwood Drive? 3 to 4 times per week. And she was there to get, from what you understood and saw, you saw her getting meth for herself and from Vic, which is Andres, right? And then West responds, I don't know if it was for herself, but yes. And then that's when the next question or complete question.
It starts by talking about before you moved out, right? So this is
Yes.
before, this temporally, the questions are referring to the time before the defendant moved in, right?
Yes, that's correct. But anyway, this does not undermine the inference that she was getting meth to distribute it, and that is what Davis affirmatively testified to on direct. Unless,
Hold on, Judge, you have any more? Judge Larson, thank you very much. We appreciate it.
thank you, we ask that you affirm.
Ms. Renee, we are happy to hear from you in rebuttal.
Thank you, and I thank my colleague for pointing out the page number, and I had cited to the wrong page in my brief, and that's why I couldn't find it. But I did find it while I was waiting. And so, indeed, it does start out on page 256, but it spills over into page 257, which is where I was getting at. We end at the bottom of, starting on page 256 on line 16, where Wes is asked, how often did you see Margaret Sutton over at the Danwood Drive residence before you moved out? 3 or 4 times a week. And you saw her getting methamphetamine for herself from Vic, meaning Mr. Andrews, right? And she goes, I don't know if it was for herself, but yes. Then the question, okay, just like all of the other, and then Sutton says, yes, pictures of people, talking about the other customers who would come there. But over on the top of page 257, where Wes answers, yes, ma'am, and beginning on line 2, the question is, so she was one of the customers, if you will, who would come over. The answer is, yes, ma'am. And then further down on page 257, beginning at line 12, talking about when she first saw Sutton coming over, and I think you testified that you met her in the fall of 2020, 6 months or so before you moved out. Is that right? Yes, ma'am. So she had seen Sutton coming over to the house for 6 months, at least, before this so-called raid occurred, as a customer, along with all the other customers who were coming over. And again, this relationship she begins with Andrews starts after Wes moves out, which is the end of March. The raid occurs on April 21st. So we're talking like a three-week period. So this information from Fant, who says, after stating, yes, I knew a guy who told a guy, and through the grapevine, someone said that, she was, somebody to look out for. People were getting in trouble if they were interact with her in any way. And that's when Fant says, oh, yes, and I was told, or Andrew says, yes, she made a lot of money from me the month before. She wasn't even there the month before. And again, of course, Fant says everything was just a big blur. So yes, we can decide to, again, pick and choose. The fact finder can pick and choose what evidence they think is believable and what is not. But when the government's own evidence is in conflict with each other, I don't think that amounts to substantial evidence. And we spend so much time, the government does, arguing about Sutton's knowledge. Knowledge is only one factor. There's got to be more than just her knowledge that there's a conspiracy going on. She has to be participating. And there's no evidence that she was anything other than a customer. And again, when Andrews arranges this trip to California that starts in Virginia, she's nowhere around. She's in Tennessee. And as far as maintaining the drug premises, even if under the word use, it has to be for the purpose of. There's no indicia of any clothes, personal items, anything like that of hers at Andrew's house, particularly in that bedroom where all of those drugs were found. And in order to even use the property for that purpose, the drug distribution has to be one of the specific purposes. Her specific purpose for being there was to spend time with her boyfriend, Andrews. And I see that I have a few seconds.
Thank you.
Okay.
Thank you very much.
I'm sorry.
I see that you're court appointed, and I want to express the appreciation of the court for your argument and the careful and conscientious approach that you've taken toward it.
Okay.
And thank you both, and my colleagues will come down and shake your hands, and if you would come up and give me a fist bump, I would appreciate it.
Thank you.
Thanks to you both.
Sole purpose of creating additional qualifications indirectly.
Is there any indication that this gentleman could not run for office?
Your Honor, our candidate was initially not going to appear on the ballot in the primary election. However, he was ultimately able to appear on the ballot and subsequently lost. However,
Can we regard something as a qualification if it doesn't disqualify anybody?
yes, Your Honor. So pointing to the
It
second
doesn't,
part,
is that just preliminarily something of a contradiction in terms?
so Your Honor, it is not a contradiction because the test outlined by the Supreme Court is that a qualification can have the sole purpose of creating additional qualifications indirectly. It does not have to be something that directly keeps a candidate off of the ballot if it possibly limits the scope of candidates that are able to appear on the ballot. Our client was ultimately able to appear on the ballot. However, as a class, felons in North Carolina.
Well, they can appear on the ballot, but is there any notification on the ballot at all that he is that he was at some point a convicted felon? That's not on the ballot, is it?
No, Your Honor, it is not. It doesn't appear on the ballot itself. However, The statute, which is North Carolina General Statute 163-106E, does require that the notice of candidacy ask a question about felony status and that the candidate
It would be a significantly stronger case if the felony designation were on the ballot.
Yes, Your Honor.
And it's not, and there's no disqualification
Your
for
Honor,
running for office. And the question, I guess, is that what kind of a political disadvantage do you put someone in? Because the political disadvantage cases, I think it's our Cook decision, actually communicated something about the candidate's views. And this doesn't, the voter goes in the voting booth and says the name, and there's no indication of felony status, and there's no indication on the ballot as to what this candidate believes or disbelieves. So I'm not sure how this, if this is a disqualification or an added qualification, it seems to me that a great many state laws that required some kind of preliminary information would then be viewed by courts as disqualifications. And if we go that route, what do we leave of the state's Article I authority to regulate the time, place, and manner of elections? This is one of the concerns that I have, is that we are nibbling and in some kind of, and in some real way, gnawing away at the state's authority in our federal system to regulate the time, place, and manner. And if this is, I don't understand the limiting principle here, because if we say this is impermissible, it seems to me that we've gone a long way to compromising the state's Article I power.
So, Your Honor, there is a clear difference between what the state can do under their Article I elections power and what they cannot do in adding additional qualifications. And I think that the key difference here is that requiring a past felon to disclose the fact that they are a felon in order to appear on the ballot is substantive. It has nothing to do with regulating the time, place, or manner of elections, as the state frames their argument in terms of this being a valid elections clause regulation.
Can you help me a little bit? So one of the oddities here, right, is that when you look at the statute and you look at the form and you look at the regulation, the state has actually added a lot of qualifications, right? You can't be a felon, you must be a registered voter. Those seem obviously to be qualifications, and I take the state to concede that those are improper qualifications that no longer apply, at least in Congress. Although I don't know how your client was to know that before you filed suit. But those do look fundamentally different from a disclosure requirement,
Yes,
right?
Your Honor.
And so what I'm having a little trouble getting is where you would have us draw that line, right? So there's obviously some, affiliation with a political party, right? The Supreme Court has said that that's permissible. But how do I draw the line where this mere disclosure of information, like a financial disclosure, would be the same thing? It seems like to me a financial disclosure would probably pass muster, right? This is a felony disclosure. Help me understand why I should think about those like being a registered voter or otherwise.
So, Your Honor, requiring someone to make a financial disclosure or affiliate with a party is different from the felony disclosure because they serve purposes under the elections clause. They help states to regulate the time, place, and
the
manner.
financial disclosure, what is that? What's the purpose served there, right? It's informing voters, right?
Yes, Your Honor.
Okay, and so what's a felony disclosure requirement doing? It's informing voters.
In a way, it is informing voters. However, it doesn't fall under the reasons why the state would be able to use their power under the Elections Clause. The state is, in essence, asking candidates to disclose their felony history and have voters focus on that as a way to look at their commitment to the rule of law. A financial disclosure or affiliating with a party does not, it serves a purpose beyond just disclosing the felony in order to inform the electorate.
What if the state said instead, we want you to check a box? Are you pro-life or not?
I think
Is there a problem there? I mean, do you think that's a qualification?
I think so, because I think that ultimately it isn't the role of the state to help people understand the views or point to a particular view for a candidate. I think that it's just to facilitate elections under the Elections Clause.
How can a disclosure requirement, here a relatively innocuous one that's not a part of the ballot or whatever, how can that not be part of the manner of regulating elections? Why doesn't this kind of thing fall within the ambit of the state's Article 1 power? The state's Article 1 power to regulate the time, place, and manner of elections is under, every little part of it is under some sort of assault. And this seems to me a relatively innocuous kind of thing, because it isn't even disclosed to the public, except the fact that it's on file. It's already a matter of public record. But it just, when we get down to this minute a question, haven't we immersed ourselves quite deeply in the minutiae, in every minutiae of the state's attempts to regulate the manner of elections? And they are given some constitutional authority to do that. And it would be a very different case for me if this were disclosed on the ballot. It would be a very different case if particular viewpoints or disclosure of, well, what are your views on this issue? What are your views on that issue? And that was part of the application form and everything. But this seems relatively modest. And if this itself is in some way unconstitutional, my gosh, we've driven a nail into the grant of authority given the states to have something to do with regulating elections. There's some leeway in that grant.
Your Honor, I agree that the state does have power to regulate under the Elections Clause. However, when you look at it, the reason why the state has the power to regulate under the Elections Clause is to ensure that the candidates that appear on the ballot meet the qualifications. But
this gets down to a very granular level. I just wonder how much this granular picking at this particular provision and that particular provision doesn't end up essentially in its totality putting a significant dent in the power, the residual power that the framers gave the states under Article 1.
Well, Your Honor, I think that the power that the framers gave to the states under Article 1 is to help ensure that people are informed about the electoral process from the state's perspective, to be transparent and to ensure that elections are efficient. And I just don't see the connection between requiring a candidate to publicly disclose their felony history and those goals under the Elections Clause of the Constitution. So I think that there lies the problem. Even if it's not directly on the ballot, it's still labeling candidates, and the state seeks to serve the purpose of indicating to voters a candidate's commitment to the rule of law. And ultimately, I don't think that that's a role for the state. The state should be able to regulate elections under the Elections Clause, but I just don't see how this fits into that box.
Can I ask an unrelated question, perhaps? And I'm happy for you to leave this to Ms. Mitchell if that's her story. Why is the felony disclosure piece not moot? I understand there's sort of a reference to capable of evading review, but that requires some reasonable expectation that your client will be confronted with this problem again. And where in the record would I find any indication that your client is going to run for office again, right? We have to have some reason to think that he's going to do this again, and I don't actually doubt that he will, but where would I look to cite that?
Yes, Your Honor. So the state actually conceded that this case is not moot. Obviously, the court could on its
That
own
doesn't really
volition.
matter to me, right? So,
Yes.
Okay.
However, there is indication on, let me see what page. On page 3 of our opening brief, Mr. Sharma did express that he may well run again. So,
May well run again?
yes.
Is that under the capable of evading review line of cases? Is that sufficient to have like a reasonable expectation? I think it's the language we use, or the Supreme Court has used. May well do it, right? Like in Lujan, if somebody said, I may well travel, like I don't think the court would have said that sufficed there. Why do we think that suffices here?
So, Your Honor, I think the other piece of it is the fact that if he were to run again and he were to fail to disclose accurately his felony history, he would be subject to a felony under North Carolina law. So it
Totally fair, but there's like a may well, right? Like if he runs again, you're totally right. And if we had some reason to think that he was going to run again, like I'm totally on board, right? This makes total sense. But I worry a little bit that, no offense to you, but a statement of the lawyer that he may well run again is not exactly like confidence inspiring about the expectation I have that he will actually do so.
yes, Your Honor, I definitely hear you. I point you to our brief at page 3, but I understand.
Thank you, counsel.
So is an interesting kind of question, because it's in applying the capable of repetition yet evading review, there's some courts that take the position, well, it has to be with the particular individual who will repeat the behavior. And other circuits say, no, we don't require that the individual repeat. We simply require that the issue reemerge. But what's interesting about this case is that you have both the expectation that the issue will reemerge and the expectation that the individual will do it again, because as I understand it, in the 2022 Republican primary for a congressional seat, this same individual challenged this requirement. And so, you have here, the individual is not only likely to do so, he has already done so. And that's sort of icing on the cake. And when the courts have looked at this capable of repetition thing, they'd say it has its highest salience in the electoral context. We have our court saying that. We have the Supreme Court saying that. And the word capable is interesting to me. It has to be capable of repetition. Well, here, the word capable requires some sort of projection. Here, we can project because we have the past conduct to refer to. So I gather you're saying to us that, if this exception to mootness doesn't apply. It's hard to imagine one that ever would.
Yes, Your Honor. And we definitely agree with that view, especially in light of, I believe it was your opinion in the North Carolina Right to Life Community Fund. You talked about this exact distinction. It could be capable of repetition, and also we know from his past actions that he has run in multiple elections. So yes, Your Honor, we would agree with that.
You know, there's something, at some point, I was thinking about this. At some point, I just can't keep kicking the can down the road. At some point, North Carolina needs some answers to some of these questions. You know, it must be a very difficult job to be on the State Board of Elections in North Carolina. I can tell you that we have received more litigation, election litigation, and I suppose it's a product of divided government, but we have received more litigation, suit after suit after suit, attacking North Carolina's election laws. And it was, if you would add them all up, you would very likely find that it is without precedent. And at some point, the State Board of Elections needs some answers, not having the whole thing totally in limbo. I don't fault anyone that brings these suits. I mean, they have a perfect right to do so, and the rest. But I just think I've never seen anything quite like it. The degree to which the election laws of North Carolina are being challenged. I don't know if somebody asks somebody that they want to serve on the State Board of Elections, are you kidding? You have to think of it from that perspective. I just want to thank you.
Thank you, Your Honor. And I just wanted to briefly conclude and say that we would ask you to reverse the decision of the district court.
That's
Thank
fine.
you very much.
Ms. Mitchell, we're happy to hear from you. You know, one thing I'm curious about is that there is a federal overlay to election procedures, but most of that overlay is generated from the Equal Protection Clause and the Voting Rights Act, and the conflict takes its sort of most obvious form when there's a racial dimension to the lawsuit. I don't see that here, except maybe very indirectly. But where we're talking about something that doesn't involve an equal protection or a Voting Rights Act challenge, doesn't the state have a greater degree of leeway than it would if there's a VRA or equal protection challenge brought? Doesn't the Article 1 power begin to expand a little bit when there's no federal racial overlay?
Yes, Your Honor, and may it please the court. If I understand your question correctly, I would agree that whenever there's not an equal protection or racial overlay pertaining to a state's elections regulation, they may have more leeway. I would agree with you, but that leeway isn't limitless, and the state still is required to justify the regulations that they put down whenever it arguably steps outside of the authority that they have under the Elections Clause.
Okay, can you speak up for me, please?
Yes, Your Honor.
Thanks.
Absolutely. So to answer your question, yes, sir, I would agree with that. However, that does not excuse the state from being required to justify the regulations that they choose to impose. So today I will discuss Mr. Sharma's challenge to North Carolina General Statute 163.8210C1, which mandates the public disclosure of political candidate addresses. Now, the district...
Sorry, it mandates the disclosure of voters' addresses.
Your Honor, by the text of the statute, it does say voters' addresses. However, political candidates having to be registered voters are swept into that group as
And
well.
below, he challenged the requirement that candidates be registered voters, but he's not challenging that on appeal, right?
That's correct, Your Honor.
Okay,
So,
just checking.
yes, Your Honor. So the district court...
And why is he not challenging that? Because everybody agrees that that's an improper qualification?
Your Honor, why he chose not to challenge that on appeal,
Do you agree that being a registered voter is an improper qualification under the Constitution?
Your Honor, I would agree that that does impose an additional qualification.
Right, so if the state of North Carolina said, as it happens to say, that you have to be a registered voter in order to run for Congress, that's an unconstitutional, at least application of that statute, in your view?
Yes, Your Honor.
So I need to understand exactly what you're challenging here with respect to the addresses. And that is that the voters have to give the address, right?
Your Honor, yes, that is part of the statute that we are challenging.
That's
facially.
the part of it that you're challenging, the fact that the voters have to list their address?
Not exactly, Your Honor. This challenge really stems from the harm he suffered as a candidate. However, that is captured underneath the statute, which by its text does refer to voters.
But we agree he doesn't have to be a registered voter to be a congressional candidate,
No,
Right.
Your Honor.
right? He doesn't need to be a registered voter.
Well, in North Carolina, he does have to be
Not
registered.
for congressional candidates, right? Because we've just established that, like, that's not constitutional. I get that they claim that they say that, but I'm going to ask him when he gets here, but I'm fairly confident that that is an unconstitutional qualification. So the challenge with that, right, is that he doesn't have to be a registered voter. So that, like, has a sort of breaks your chain argument, right? That because I have to be registered, I there have to disclose my address?
Yes, Your Honor. However, I would say that that does not break the chain because in order to place his name on the ballot as a candidate in North Carolina, he does have to publicly disclose his address on the candidacy form.
But I'm still not clear, and this is my fault, not yours. Is the challenge brought on behalf of this particular plaintiff that he has to give his address, or is the challenge to the law that all voters would have to give their address? Which one is it?
He challenges facially that he was compelled to place his address on the candidacy form.
Okay, that he was required.
Well, he brings a facial challenge saying that as this would be applied to anyone here.
But is he also challenging on behalf of voters who have not been convicted of a prior felony? Is he challenging that on behalf of every voter?
Yes, Your Honor. So he is bringing this challenge separate from his felony disclosure claim. And whenever he...
Well, I know it's separate from the felony disclosure claim, but I'm wondering whether he's only attacking the address requirement in the sense that as applied to him, or whether he's leveling a larger facial attack and saying this is wrong to require every voter to give their address. Which is it?
Your Honor, it's the second one. He is bringing a facial...
That every voter is required.
I thought in his complaint, the First Amendment part is it chills the First Amendment right to seek federal office for the U.S. House of Representatives. I didn't see a challenge to the First Amendment. Wrong about that.
Your Honor, you're not wrong that that complaint does state that claim in that way. However, his intent in construing that complaint liberally, his intent is to bring a facial challenge against the address disclosure statute. And in fact, the state did concede that this is a facially over...
Well, but that's like a different challenge, isn't it? What's the First Amendment argument that it violates the rights of all voters in North Carolina? Like there's an argument there, maybe to be made, but it's not the argument that's in this complaint.
Right, Your Honor. Mr. Sharma's argument is that as it applies to any voter in North Carolina and any political candidate, the North Carolina statute at issue here compels speech when he would otherwise remain silent, speech that then chills his ability to exercise his First Amendment right to avail himself of the ballot, which is a cognizable injury under Article 3, and which is why
But it didn't chill him, right, though? He ran for office.
the fact that he did overcome the chill and ran for office, but the fact that he ultimately made it past that experience and placed his name as a candidate does not negate the objectively reasonable chill that he did suffer whenever he was made to compel that speech.
But and I guess we'll find out if the state would compel him to reveal his address again in the future. But if they won't, there's like no likelihood this would happen again, right?
If the state removed the requirement that Mr. Sharma or any candidate place their address on the candidacy form and publicize it on the internet, then no, Your Honor, that would solve the problem.
That's separate from the requirement that voters' addresses go on the internet. There's a law in North Carolina, if you're a voter, registered voter, your home address is on the internet. But if the state says, we're not going to require candidates to put their home address on the internet if they're not registered voters, right? Because there's a break in the chain if you no longer have to be a registered voter to run for office, then his problem is solved, right?
Yes, Your Honor. Ultimately, Mr. Sharma would suggest that the state of North Carolina could remove that requirement altogether and also remove the addresses that are already uploaded on those websites. But I would agree with you.
Can I think maybe I was confused. So there seemed to be two things going on, and I'm maybe not understanding which you're challenging. I understood you to be challenging, 82.10C, which requires the County Board of Elections to make all voter registration information public, right? And that I understand that argument. You seem to also be arguing here that there's a separate violation because when he filled out the form, that required him to put his address on the form, the candidacy form, right? Which would be unrelated to 8210C.
That is correct, Your Honor. That is
Okay, and so what I'm trying to figure out is what's the statute that requires that, and where do I see anything about that before today? I mean, when I look at the brief, right, like the brief is all about this 8210C. The district court is about 8210C. I understand there might be another statute that requires like a candidate to disclose his address, but that's like a separate challenge. Where do I see this, candidacy form challenge as opposed to what appears to have been the primary argument, at least, if not the only argument, about 8210C?
So, Your Honor, 8210C does require the publication of voter registration information, but captured within that category of voter registration information will be the addresses of candidates.
Okay, but that's separate from the form, right? That's going to be true whether the form requires an address or not, right? So the form says, like, put your name, and then it could either say address or not, right? But that's the form, right? The voter piece is totally separate. Imagine for a minute that the voter piece didn't exist. Are you making a separate argument that when he filled the form out, he had to put his address down and that is the violation?
Yes, Your Honor.
Okay, and where do I find that in the complaint, the district court hearing, or your brief on appeal?
Your Honor, Mr. Sharma alleged that First Amendment violation as stemming from his requirement of placing his name on the candidacy form on Joint Appendix page 47, lines 16 to 17, and 48, 12 to 13. These are where he originally set out that First Amendment argument as it comes to him as a candidate.
Okay.
Does the candidate, sorry.
Go ahead.
I'm also surprised to hear this candidacy form argument, and I'm wondering if the law in North Carolina requires the candidacy form address information to be placed on the internet, right? The statute that you argue about in your brief actually requires that it be on the internet, available in a digital format. Is that the same for the candidacy form address?
Yes, Your Honor.
And where is that in the law so I can look it up?
It's captured under under that same statute.
It all goes back to the fact that you're a voter.
Yes, Your Honor.
So there's not an independent requirement that candidates' addresses, whether or not they're a registered voter, go on the internet in North Carolina.
Well, Your Honor, as a candidate, you are required to fill out this separate form. And so while I can't direct you to a specific statute referring to candidates, that form is the vehicle by
It
which.
goes through the voter registration statute.
Yes, Your Honor.
So when I look, I just want to make sure I understand. So I looked at 47 and 48. I understand that's where he says this is a First Amendment violation, but everything else I read, but doesn't say anything about the form, the candidacy form, as opposed to the voter disclosure law, right? And so everything I've seen is about the voter registration law, which indirectly discloses his address. I totally get that, right? But today we've got a separate argument that, like, when he filled out the form that required him to check, I'm a felon and whatever it is, that was the constitutional violation. And what I'm trying to find is where in the record or in your brief that argument was raised by your client.
Your Honor, in our reply brief on appeal, we do argue that the compelled disclosure on the candidacy form is where the injury stems from, which is the chill on his First Amendment rights. And we argue that that is what puts this act vulnerable to an exacting scrutiny review. In the lower record, the joint appendix on page 261 is where you'll see the form itself attached. And that is where, next to the address disclosure requirement, you can see the state has placed a message there saying this information will be made public.
Oh, I totally understand. You could make the argument, right? But the challenge I've got is, and I'll look back at the reply brief. I'm not sure the reply brief would help you. It's got to be raised in the opening brief. But I understood all of your argument, and I was last time, and I'll stop. I understood your argument to be about 8210C. And then here, it's about a form, which is not part of 8210C, is not required by 8210C. Nothing about 8210C, to me, governs the form. You could make a form argument, but is there anywhere other than your reply brief that I should look to see that argument having been made before today?
Your Honor, it is brought up in our initial brief on appeal. I don't have.
Where should I? Okay, that's sure. Maybe on reply you can just point me to where it is you want me to look. I just want to see if this is an argument that's preserved. I understand it could be an argument. I'm not sure it's a winning argument, but it could be an argument. But I didn't understand this to be an argument before today, and I want to make sure if it was properly presented that I can consider it.
Yes, Your Honor.
Thank
I'd be
you.
glad to do that.
I have the same question in terms of whether what I'm hearing today lines up with what I thought this particular challenge was about. I thought it was a challenge on behalf of all voters, of which the plaintiff was one. That there was a chilling effect in requiring for registration that voters list their addresses, and that was what produced the chilling effect. And that was what I understood. The chilling effect would presumably fall on all voters, of which the particular candidate, in our case, was one. That's what I understood the argument to be. That because he was part of this class of voters, and he was required along with other voters to list his address, that produced an impermissible chilling effect.
Yes, Your Honor, and that is a way to look at this argument, and perhaps that's how it is articulated more clearly in our brief.
But that's how I understood the argument was framed for me, that there was a chilling effect on him because he was a part of a larger class of voters who were required to give their addresses.
Yes, Your Honor, and that is true, and he is also part of the group of candidates that, by that same statute, is compelled to place his address on the form.
Thank you.
Thank you, Your Honors.
Mr. Bride, we'd be pleased to hear from you.
Good morning, Your Honors, and may it please the court. My name is Nick Brode. I'm in the North Carolina Department of Justice.
Can you pull your mic up?
Sure. Is
Thank
this
you.
better?
Yeah, that's much better.
My name is Nick Brode. I'm in the North Carolina Department of Justice, appearing on behalf of the defendants. On this last point, I think I might be able to clarify. I had also understood, as Your Honors had suggested, Mr. Sharma to be challenging the disclosure of his address as a voter, not a challenge to the form, Judge Richardson, as you had mentioned. I had understood all of the arguments in the opening brief to center around this constitutional challenge to 8210C, which makes voter addresses publicly available information. And the allegation that Mr. Sharma has made in his complaint, as I understand it, is that that chills his ability to speak as a candidate because he's afraid that the public availability of his address might make it more likely that he is threatened or harassed as a candidate. I had never understood the challenge until this morning to be to the form. I had just understood it to be the statute.
Do you agree that North Carolina's requirement that you be a registered voter to run for Congress is unconstitutional?
Yes.
And it would not be applied against a congressional candidate?
Yes.
And I presume North Carolina either has or will, in revising its forms and information, make clear to future candidates. I mean, one of the things that's bothersome here, right, is this plaintiff could be a very smart person, could read the statute, could read your forms, and believe that he was prohibited from running for Congress, when I think we now all recognize that that would not be true.
Right.
Okay.
Yes, I completely agree with that. We conceded this below in the district court. This is at JA 127, footnote 4. We have conceded this in prior litigation with Mr. Sharma dating back to 2022. And we have since updated our notice of candidacy form with respect to the felon disclosure provision to try to prevent these kinds of confusions.
I know the felony
happening.
disclosure provision, but the registered voter provision doesn't seem, the concessions and amendments don't seem quite as clear.
I don't dispute that. And I think these kinds of government forms can always be better, and we're always trying to improve them. And we've tried to improve them in one respect, and perhaps the conversation this morning will allow us to improve them in another.
It's a very wise concession on your part, because it makes the felony disclosure requirement a great deal easier to sustain. And without that concession, then it begins to seem more and more like an additional qualification. But with the concession, it becomes to seem less and less of an additional qualification. And that's why when I read the concession, I said, that's a very wise, a very wise concession to make.
Well, Your Honor, I mean, just to underscore the importance of the concession, I mean, I think that the best piece of evidence that I have on this is that Mr. Sharma himself appeared on the ballot in March of this year. So I think this is not the kind of case, as was the case in Thornton, where you have a candidate who is completely barred from appearing on the ballot. I think the only route for Mr. Sharma to prevail here on the qualifications clause issue is a Cook-style argument that even though he was allowed to appear on the ballot, that nonetheless this disclosure rule had the indirect effect of imposing a qualification.
Speaking of the March primary, which is now over, can you give me North Carolina's view on this capable of evading review idea, and why? I understand the 22 litigation, and maybe that gets us part of the way there, but the plaintiff here has merely alleged, even if we take the briefing as a sort of allegation, that he may well do something in the future. How do we get to a reasonable expectation here?
Well, so I suppose I don't want to fight you too hard on this.
I know, but you're appearing as an officer of the court, and so I'm asking for North Carolina's view. I framed it that way particularly.
Well, so I would point the court to the Fourth Circuit's decision in Leak, which we cite at footnote 2 of our brief. And my understanding of Leak is similar to what Judge Wilkinson was discussing earlier, which is that it allows for a finding of capable of repetition yet evading review if there is a sufficient indication in the record that a candidate may well run again in the future. And it seems to me, in light of Mr. Sharma's prior litigation against us in 2022 and this conceitedly somewhat vague statement in the brief that he does intend to run
Normally,
again.
these capable of repetition cases don't come to us where we already have evidence of the repetition.
That's right, Your Honor. And I think the prior litigation that Mr. Sharma was involved in against the state board in 2022 is, again, combined with the statement in his brief, sufficient from our perspective to allow the case not to be moot. And again, I would point the court to the court's earlier decision in Leak as supporting that proposition. I'm happy to answer any other questions about mootness, Judge Richardson, if you have them. But I do want to get back to Cook because I think this case is quite different from Cook in several important respects. So, Judge Wilkinson, as you were discussing with my colleague a little bit earlier, I think the most important difference between this case and Cook is that this case does not involve any kind of disclosure on the ballot itself. And as I read Cook, that was the most important thing that the court was concerned about. The court was really concerned about the state coming in at sort of the 11th hour and interfering with voters' independent decisions about which candidate they might want to select. And that's not happening here. This is an entirely off-ballot disclosure.
Can you tell me why you think that is? Is the ultimate question the sort of intent of the law, and placing it on the ballot is just really good evidence of intent? Is that the sort of move that you're making?
That's how I read the court's decision in Cook, is that it's mostly asking sort of purposes and effects questions. And when you have the disclosure on the ballot itself, it just supports a really strong inference that the underlying purpose of the state was to try to interfere between the link between the people and the national government, which is sort of what the qualification.
I'm sorry, I didn't hear what.
Between the people and the national government. The people have a right to elect representatives to Congress without interference from the states. I mean, I think that's sort of the central insight of Thornton and of Cook. And I think when you have an on-ballot disclosure, the court in Cook was clear that the inference of interference there, or some sort of intentional desire to prevent certain types of candidates from appearing in Congress, was particularly strong. I think the inference was even stronger in Cook because the state there had singled out one particular political issue.
So it seemed that this disclosure requirement seems of a relatively innocuous nature because it doesn't involve anybody's beliefs. It doesn't involve anybody's views. It's simply a factual matter, which probably is already a matter of public record if someone seeks to inquire. It doesn't involve any ballot reference to his felony status. I think that would plainly be out of bounds. And I was thinking, I don't know that I would have been in favor of this requirement, but that's a totally different question from whether the state is acting within its constitutional authority to act as it did. And to me, the strongest argument that the state can put forward here, and it pertains to both the additional qualification statute and the First Amendment Anderson issue. If the state has an overarching interest, or can at least assert an overarching interest, which a federal court would be reluctant to strike down, is that it wants to simply emphasize in an ever so modest way that it's not a good idea, or it's a good idea to note that we don't want someone who aspires to be a lawmaker to have been a lawbreaker. Now, that doesn't seem to me constitutionally illegitimate to recognize that there is a difference between lawmaking and lawbreaking. And you want at least to draw attention to the fact or to underscore in some very modest way that it is an odd sort of thing for someone who has broken the law flagrantly to then seek to become a lawmaker. There's a contradiction in there, and to say that North Carolina is constitutionally disabled from even noting that fact or from having the fact noted seemed to me a real incursion on the Article 1 authority, which still must mean something, because the way this thing is, the way the tides are flowing now, is that we're whittling down the Article 1 power step by step by step and maximizing federal oversight and interference and everything with the state's traditional authority. And as I mentioned earlier, in North Carolina, there's an epidemic of this stuff. I can't even imagine how large the elections component of the Attorney General's office is. Because if you're not defending one thing, it's another, or if you're not, in some cases you're on both sides of it, and it's got to be, it simply exceeds anything I've ever seen. Well, is that a correct assessment of?
Well, Your Honor, I guess I'll underscore a couple of things about what you said that I completely agree with. So one is, I do think it's very important that this is purely factual information that is already publicly available. And I think one way of looking at the notice.
You say it's purely factual, but Judge Wilkinson just suggested it's like viewpoint driven, right? That as Judge Wilkinson tells it, someone who's been convicted by a court of breaking the law is somehow not in a position to make law. I'm not ascribing to that view. I'm just saying that seems like that's a viewpoint political issue, not totally different from let's take a random example, term limits.
Your Honor, I think it's different because this is just a disclosure. It's a disclosure that is.
I understand where it shows up, right? But the point I think that was being made was not about whether it's on the ballot or not. I totally understand that argument, right? Your response is, oh, this is just purely a factual matter. Well, so too is it purely a factual matter that I oppose term limits or I approve term limits, right? Whichever the case might be. At some level, that's a factual matter, but it's a viewpoint, right? That's not a viewpoint neutral idea, it seems like to me.
I do think this is a viewpoint neutral kind of a thing. I don't think that this ties any particular candidate to one stance on a specific issue. It's just a piece of historical, factual information that is employment related. This is one way of looking at this form.
Why do you think it's relevant for a candidate?
Well, I think it's relevant because this is something like a job application. And I think we've all had the experience of filling out a job application and disclosing criminal history. And this is a particular type
Why
of
is
job.
criminal history relevant for a politician? These are, I don't know how far you want to go down this road. I'm just saying those are not unloaded questions, right? This is not like your, measurables at the combine, right? This is your age, weight, and 40 time, right? These are issues that implicate, it strikes me, particularly sensitive viewpoints and positions.
So, Your Honor, I'm not sure that I agree that the mere disclosure of a prior felony implicates any kind of political viewpoint one way or the other. And I think by requiring only a disclosure, the law in this area is allowing voters to take that information and do with it what they will. The state is not coming in and trying to put a thumb on the scale or tie the existence of a prior felony to a specific issue like are you pro-life as you,
So do you think if they put it on the ballot that it'd be okay? I mean,
No.
I'm trying to figure out whether this matters to you, right? So I understand your first line is it's not on the ballot, so it doesn't matter. But you seem to be making a second argument that this is just a factual question. If you're talking about that, it strikes me that you think it matters. It doesn't strike me that it's like any more purely factual than the question of whether I'm pro-life or not, or whether I support term limits or not, or whether I believe in a vibrant Second Amendment or not. Those are all factual questions at some level of what my beliefs are, or, where I went, all of these are sort of questions that are factual in nature, but they implicate, it strikes me, as particularly strong political viewpoint questions.
Your Honor, I mean, it may be a question of degree here. I mean, I think if we're talking about specific issues, whether you're pro-Second Amendment or pro-life, I mean, that to me seems very directly relevant to a particular political viewpoint, a particular political topic, in a way that just isn't at issue here. There's nothing...
Is the idea of being a convicted felon is like totally irrelevant in this election cycle? Like it just hadn't come up?
No, I mean, I think I'm looking at it from the perspective of the candidate. I mean, whether you check that box, yes or no, doesn't tell you anything or require you to disclose anything about your particular political views in the same way as a box saying, I am pro-life or whatever else might. And I do think this is a question of degree. I don't think that a felony disclosure rule of this kind necessarily implicates political views, a particular candidate's viewpoint on a subject matter, as was the case in Cook, or as you might imagine with various hypotheticals. And I will go back just to underscore my earlier point about how I do think this is something like a job application. And I very much take the point, Judge Wilkinson, that this is a specific kind of job. You are being hired by the voters to make law. And as a result, I think it is reasonable for the voters, who are the employers in this situation, to ask about prior law breaking. And as I said, the voters can do with that information what they will. There's no effort in this case, as there was in Cook, to kind of put the thumb on the scale to benefit one type of candidate or another based on their political viewpoint or the way that they're seeing a particularly contentious political issue.
Just if something in some remote way may conceivably be viewpoint discrimination. I don't think this is viewpoint discrimination, but no matter what it is, you still, in every First Amendment case, have to take cognizance of the state's interests. It's not an area that is, when you say, I agree with you, and you say it's a matter of degree. Another way to put that is, and it's, I think, plays off your point here, that it is not a matter that is free from balancing. And part of the balance here is the state's historic Article I authority to regulate the manner of elections. And another part of the balance here is that a state is constitutionally able to differentiate between law-breaking and lawmaking, and that it's important to recognize the difference. And so we can say, well, what does this disclosure do, or what does it doesn't do? What it does do is relatively innocuous, because it's not on the ballot. It's not, they're not blaring at it with sirens. It's not disqualifying in any way. And you have to balance the relative innocuousness of it against the weight of the state's interests. And the state's interest is derivative of two things. Number one, the constitutional grant of authority in Article I, and then in addition, the general authority, which would be independent of Article I, to differentiate between the function of law-breaking and lawmaking. And if you expect citizens to obey the law, and if there's any sanctity at all to the rule of law, one would apparently seek to recognize a distinction between breaking law and conforming and abiding by law. And that goes right to the heart, not just of Article 1, it goes to the heart of what law is all about.
I completely agree with that, Your Honor. I completely agree. Unless the court has any further questions, I'm happy to stand on our briefs. Thank you.
Okay. All right, thank you, sir. Ms. Mitchell, I don't know, we'd be pleased to hear from you on rebuttal.
Thank you, Your Honor. May it please the court, before I get back to Judge Richardson's question about my issue, I'd like to briefly address a couple of things on the qualifications clause argument. First, the state has conceded that the felony requirement on that form is unconstitutional, but the statute on addendum 11 of the state's brief has not been changed. And so while the form may have been changed, the statute remains the same today. And secondly, when it comes to the issue of mootness, Judge Wilkinson, you're correct that this is capable of repetition. Mr. Sharma is young, he's only 27, and he's already run for office twice
Seems
before.
like both of you all want to get this question resolved one way or another, do you not?
Yes, Your Honor.
So,
That's often true when the parties want to agree about jurisdiction, right?
Yes, Your Honor.
Can you, when I look at page 3, and I confess I just read it quickly, I don't see the may well run again on page 3. Is there somewhere that I can look where he makes some indication that he's going to run again? I totally get the leak point. Maybe we can infer it from the fact that he's done it twice. But is there anywhere else other than page 3 of your brief that I can look to see this notion where he represents, either through lawyers or otherwise, that he has any intention to run again?
To my knowledge, Your Honor, there's nowhere that's more concrete than as he may well run again. And then returning to my argument on the address disclosure rule, apologies.
I'm sorry, he may well run again, and you say that is on page 3 of the brief?
I believe so, Your Honor.
Okay. I may just be missing it.
I believe that it is page 3, has it?
Okay, I can look, that's okay.
Sure. So apologies for any confusion on the candidacy form. I want to clarify that the challenge today is to the statute. It's a facial challenge to 163.8.2.10c1. Now, the candidacy form is
the challenge is, I just had a basic question about standing on this point because, whether the challenge is just an as-applied challenge to him alone or whether it's a facial challenge sweeping in all voters. The chilling effect of it all seems to me to be so very speculative. I'm just not sure how listing addresses, we list addresses for everything. If you want some sort of benefit from the state, if you filling out an insurance form, if you're going to a doctor's office or whatever, you want a driver's license, you're listing your address everywhere. And I just wasn't sure how such a common disclosure that we're forced to give, we give every time we turn around in life. How does, the chilling effect is not here, it's not that, it is so far on the far horizon. What concrete, what non-speculative view can you offer about this chilling effect?
Well, Your Honor, I'll answer that, if I may, in two parts. So first, when it comes to the election context, the compelled disclosure of your address takes on a different level of concern than where you compelled to disclose your address in other contexts. So
It's clear that this address requirement applies to all voters.
yes, Your Honor.
So, that runs into the different problem of the fact that the injury may not be particularized.
Yes, Your Honor. Well, as this is a First Amendment challenge, that chill can be and has been suffered by, can certainly be suffered by anyone who is being compelled to disclose their address as a voter or candidate, and it has been here. As Mr. Sharma himself has said that he had a very bad feeling. We know that he experienced a chill as he thought about the amount of death threats and harassment and stalking that political candidates are subjected to in today's political climate. So that is where the chill comes from for him. And the other point that I would make on that is that this court has found an objectively reasonable chill.
At this point, I'm going to ask my fine colleagues if they have further questions. Judge Richardson, do you have some further questions?
I don't, thank you.
I want to thank you, and Mr. Corzine, thank you for bringing such able student counsel, and you should return to the law school and tell that community what a fine job they did.
Thank you, Your Honor, for the opportunity. Thank you.
Thank you both. And could you, my colleagues will shake hands with you, and I always tell counsel, if you're mad at me, you don't have to come up. But otherwise, I'd love to see you. Thank you for your good argument. I really appreciate it. Got a wonderful career as a lawyer ahead of you. Hi, you too. Good luck on your future legal career. So wonderful. Hi. Pleasure to see you. Thank you, sir. It's good to have you here always. Jay, do you want to take a break?
Creek Partners filed 2 lawsuits in the Eastern District of Virginia, its home forum, and it was entitled to heightened deference in its choice of forum. And we're here today because we contend that the district court abused its discretion in dismissing this case based on the doctrine of forum nonconvenience. I'm going to spend time talking about the standard because ultimately I think that's what this case turns on, and I'm going to talk about how the court applied the various public and private factors and how the court erred and how those factors would not meet the standard if properly applied. Before I do that, I want to spend just a moment talking about what these 2 cases are, what they're about and how they're sort of the same and how they're also a little bit different. Illume 1, that was a breach of contract case. It was between 2 parties that were both U.S. entities. Tiber Creek Partners is an LLC. It's based in Virginia. Illume USA is a U.S.-based company. They're incorporated in Delaware, but they had a manufacturing plant in Frederick, Maryland. Tiber Creek was hired to do some work, some consulting work. It was paid some of its fees. It wasn't paid all of its fees, so it brought a lawsuit in its home forum. Illume 2 involved Illume USA's parent company, which is an Australian company, and the gist of Illume 2 was a declaratory judgment claim to have an amendment to the first contract declared invalid based on fraud. Tiber Creek contended that
I'm not entirely clear who you're contracting with.
Well, so
There's, one Illume that had headquarters in Australia and another one in Maryland. Who got these different contracts and different agreements and different amendments and everything? Who are you contracting with?
the Tiber Creek, our position, and it's clear in our briefs and our complaint, the contract was with Illume USA. The contract was very clear that Tiber Creek was going to provide consulting services, and the payment obligation belonged to the party that received government funding. And I don't think there's any dispute that the entity that actually applied for the government funding and received the government funding and paid Tiber Creek the prior fees was Illume USA.
A question on that point. Do you think that the inquiry here is sort of a probabilistic one? So imagine I took this sort of idea that this threshold question in Tiber 1, just keep them separate. So in Tiber 1, there's this threshold question of whether you sued the right entity. And if you sued the right entity, then the case proceeds and we have a set of circumstances. If you sued the wrong entity, the case will be dismissed because you have sued somebody with whom you have no contract. Is the district court and are we supposed to look at that in some probabilistic sense and say, we don't have all the evidence, but my best guess is that there's 60-40 one way or the other, and then I then take those probabilities and run them down to the likely outcomes of what would happen and ask about the convenience and the public and private factors given the likely outcome of this threshold question?
I don't think that you get to that question on the forum nonconvenience analysis because the argument was that Tiber Creek sued the wrong party. They also filed a 12B motion saying the complaint should be dismissed because in Illume 1 anyway, the party to the operative contract was not Illume USA. That was a 12B argument that they raised that the court never got to.
But the forum question, I mean, we're told by the Supreme Court, the forum question is a predictive judgment by the district court, right? What is litigation gonna look like? It's by definition making a prediction, right? What is the litigation gonna look like based on the arguments of the parties? It doesn't know what trial is gonna look like. No, I mean, nobody knows what trial is gonna look like. It's making a predictive judgment. The question I'm asking, so that's a predictive judgment about what trial will look like. But we know in Tiber 1, or at least let's accept that there's a 60-40 question at the threshold as to who the right contracting party is. And so if I look at it in a probabilistic manner, that might affect the balance that I have. I'm just asking, do I do my predictive judgment assuming you get to trial? Or do I do my predictive judgment looking through the lens of there's a 40% chance, and I'm making up the percentage, a 40% chance that your case is dismissed because you sued the wrong counterparty?
I don't believe that you look at it in the latter way.
Why not? I totally understand that, but why not?
Because the inquiry on a forum nonconvenience analysis, according to D. Federico, is whether the plaintiff's forum, the chosen forum, in this case, it was the home forum, that choice is entitled to heightened deference. So the question is whether the forum is not just inconvenient, but vexatiously
I understand the bar's high. That's a bar's high argument.
Right.
What I'm asking is, when I look at the convenience of the evidence, right, one of these private factors, right, when I look at the convenience of the evidence, if the case goes to trial, I might have one view. But if the case is dismissed, because you sued the wrong counterparty. I don't have any evidentiary problems, right? There's
Well,
no,
I agree with that.
and so then the question is, am I looking, and I'll move off of this
Yeah.
if there's no answer, right? But am I looking at those two probabilities as a threshold matter, or am I ignoring that possibility, whatever it is, that your case is going to go away without looking at any evidence?
Yeah, the court is directed by the precedents to look at the public and private factors, which do look at, to some degree, how this case will take form once it goes to trial.
It was a totality of the circumstances inquiry.
It is a totality of all of the court is directed to look at all of the public and private factors.
Nonconvenience is a totality of the circumstances inquiry.
It's a totality of the circumstances inquiry, but it's a very, very high bar to dismiss.
I understand that you think that all the circumstances are not equal circumstances.
Right.
But one thing I'm thinking, this is a battle of presumptions. You have the presumption that you bring forward about a plaintiff gets to choose the forum, and then there's the countervailing presumption that we're here under an abuse of discretion standard, and that a certain deference is due there. So you've got these clashing presumptions. And the question I have is, I can't think of very many cases where we have reversed district courts under an abuse of discretion standard, where they undertook a totality of the circumstances inquiry. Most of the abuse of discretion standards, or a great many of them, concern an error of law, which is automatically an abuse of discretion. But where the district court inquiry was one of the totality of the circumstances, then we've been very reluctant as an appellate court to reverse. And I say that because that might have a particular applicability here, and that is, we do not want parties thrashing around on preliminary issues without the idea is to get to the merits and resolve the merits as soon as possible. And if we have them thrashing around on a preliminary issue like forum nonconvenience and everything, that simply postpones things, and it runs up the expense. Both of those things. I don't understand why we wouldn't credit or go out of our way to credit what the district court did, the discretionary call that the district court made, where it's made under a totality of the circumstances framework. In that light, I'm not sure how I can see how the district court ran off the rails here. I mean, he says that I can't control the discovery in Australia, and the witnesses are in Australia, and the documents are in Australia, and Loom's headquarters in Australia, and there's an Australian bankruptcy court, a bankruptcy proceeding in which your client participated. And so, I'm thinking, this isn't a district court, the discretionary ruling that ran off the rails, and I don't know why we wouldn't, I don't understand why we wouldn't back it up, because the longer we go on thrashing around with this discretionary issue, as I say, it takes time, it runs up expenses, and the bankruptcy estate is meantime the bankruptcy estate is going to be bleeding funds and maybe more attorney's fees, but in terms of actually getting this case resolved promptly, I don't see how the district court ran off the rails.
Your Honor, in DeFederico, the district court looked at all of the factors, the witnesses, the public and private factors that were raised here. All of that was at issue. And in DeFederico, the court stated that those circumstances, and I think they're far more weighty than the circumstances here, even still do not override the plaintiff's choice of forum under the heightened deference standard. This court in DeFederico stated not just the standard, but there must be evidence in the record that the court actually applied that heightened deference standard. In our record, to the extent there's any evidence of what standard the court was applying, it's some sort of a balancing test. We quoted in our brief, it's on Joint Appendix 773. The court stated, so this really comes down to...
So I understand the standard. Can you like pick a factor that you think the district court got most wrong, right? One of the public or private factors, just to give me an example.
Okay, witnesses. Yep. For example, as I see the case, all of the witnesses in Illum 1 are in the U.S. They don't apply, that factor doesn't even apply to Illum 1. In Illum 2, yes, there are...
Stay with Illum 1.
Okay.
Right, so the witnesses is here. What else? So that, in considering Illum 1, the district court erred in finding that the witnesses were in Australia, or at least predominantly the witnesses were in Australia.
The possibility of a stay based on the Australian proceeding, that only applies to the company that is the subject of the deed of company arrangement. That was Illum Limited. It was not Illum USA. There was no bankruptcy protection available to Illum USA, period, at all. Now, we of course say that Illum Limited wasn't entitled to it either because they didn't go through the Chapter 15 bankruptcy process in the U.S. bankruptcy courts. In terms of the witnesses for Illum Limited, DeFederico says that factor, the witness factor, is to be given little weight in the absence of evidence that those are unwilling or unavailable witnesses.
I think the district court listed Richard Hughes and Brian Moeller and Mark Anning and David Green and Paul DeRuze and the Illum Ltd's administrators as witnesses who were in Australia.
Yeah, and they're under the control of Illum Limited. They are not unavailable. And that factor is only entitled to...
That's not the only... I mean, the Supreme Court, DeFederico mentioned unwilling witnesses, but they were quoting and talking about a standard the Supreme Court set that follows up unwilling witnesses and the cost of bringing willing witnesses, right? So we can't just look at what was most important to DeFederico. We have to look at the entire standard and what's the district court thought was most important here.
Well, I think what the district court said and what you're saying makes more sense with respect to Illum 2. It does not apply to Illum 1 at all. Those witnesses have nothing to do with Illum 1. As we see it and as we stated in our briefs, the standard is very high. It's a heightened deference standard, and there must be evidence in the record that the court applied that standard. The court didn't even state the proper standard in the record.
So the court also pointed out to the fact there's a bankruptcy proceeding in Australia. The court says you participated in that. Is that correct?
Yes.
Okay, all right. You participated in that. Now, the concern that I have is if you look at this case in terms of bankruptcy, you may be correct in your breach of contract action that you are a creditor here. You may be correct that you deserve to be paid, that you indicated that you performed some valuable finder services. But, you know, in bankruptcy, nobody, no creditor or few creditors get completely satisfied. Creditors' claims are subject to priority. They have to be content in many cases with a partial recovery. And if I put on a bankruptcy court lens to this, I was concerned that you were trying to jump to the head of the line in terms of the estate, whatever estate a loom has. But you didn't want to take your place in line in that Australian proceeding. And if you could come to the United States and just come with a clean breach of contract action, you could escape all those pesky little things like the automatic stay and other things that were going to keep you from a full recovery. But what troubled me was, in addition to the witnesses, the documents, and all the rest that the district court listed, I was concerned that this might, to some significant extent, be a bankruptcy matter in which you voluntarily, or which you've participated, and that you are now trying to circumvent the bankruptcy proceeding in Australia and wage your own little proceeding here in the United States, and jump to the head of the line and not have your claim subject to 962D or whatever the automatic stay provision is. And to say that in this context, that the district court abused its discretion under a totality of the circumstances inquiries, it strikes me as a rather dramatic thing that you're asking us to do. You may be right, I don't know, but I have these qualms about what you're saying. I want you to put me at ease.
Your Honor, I'm out of time, but if I may, I would like to put you at ease.
That's fine.
So factually, to understand what was going on when Illume filed this lawsuit, there was a process going on. Yes, there was a voluntary administration proceeding because Illume Limited was insolvent. There was, at that time, a process by which the administrators were going to sell the company to a new investor that was going to come in and pay $50 million.
What gives you the right to bring your own little lawsuit in the United States when you participated in Australian bankruptcy proceedings and now you wish to be rid of them?
So, Your Honor, Tiber Creek's position is that the party that owes it money is Illume USA. That's our position. That company is a U.S. company.
They are not in bankruptcy.
They're not in bankruptcy. We filed the lawsuit. It was in response to some early motion skirmishing where we realized that Illume USA was going to take the position that they were not the proper party to the case.
And so in Illume 2, you're not seeking money from Illume Limited.
Exactly.
Right? You're seeking a declaration that they fraudulently induced these contracts.
Correct.
Right? And so if you prevail in both of these suits, the result of that would be that a U.S. company would have to pay its U.S. contracting party for having done U.S. work in order to get U.S. government funds.
Exactly.
And then in Tiber 2, what would happen is nothing with respect to the bankruptcy proceeding, and Illume Limited would pay no money, and it would have no impact on Illume Limited's bankruptcy because the results of Tiber 1 would have showed that you're not involved in the bankruptcy proceeding.
Correct.
And so prevailing, if we consider you prevailing as part of this calculus in trying to determine whether the bankruptcy would be affected, there's no world that you prevailing leads to a consequence in the actual bankruptcy proceeding.
That is exactly correct.
And if you lose, let's imagine you lose both cases, well, in that case, you also are not going to get money from Illume Limited because you have no right of recovery.
Exactly.
Right? And so whatever in the world happens here in the United States, where a U.S. company contracted with a U.S. subsidiary to do U.S. work to get U.S. government funds, whatever happens here, it is not going to pull money out of an Australian bankruptcy.
Yes.
Right? And so the question is, the obvious softball question is, why in the world do we think the Australian bankruptcy proceeding has a single thing to do with whether this is the proper forum?
Yeah. It doesn't. It has nothing to do with it. And the only thing I would add to what you just said, Judge Richardson, is that in Illum 1, even before Illum Limited was part of the second case, there's a claim in Illum 1 that says, to the extent the Australian bankruptcy court awards some money based on that proof of claim that the administrators asked Tiber Creek to submit. If they do that, it will reduce Illum USA's debt.
You playing a shell game with me?
I don't think so, Your Honor.
Illum Ltd. and Illum
I hope I'm not. So
USA and
it's hard to keep track of sometimes, but our beef,
Did you
complaint.
set either of those entities up?
fault is that?
No, we did
Right?
not.
These are shells that are created by Illum, right?
Yes.
Two different
They're
entities.
two companies, yes,
Right.
created by Illum. Correct. Thank you, Your Honor.
Can I just ask a
Yes.
follow-up question on that? So you're conceding that the filing after the judgment, informing the court that there was no money in the bankruptcy estate is irrelevant because you're not getting money from the
Yes,
bankruptcy
there
estate.
is no money.
So you're
Tiber Creek has
conceding-
gotten no money.
You're conceding that point. You filed something, you appealed saying the district court was wrong to reject that, but you're conceding now it was correct to reject that because the bankruptcy estate is irrelevant.
I think that's correct. Yes, I will say yes. I think the court should have considered that evidence, but I don't think it matters, if that answers your question.
All right, so that's different from your brief. It doesn't matter because the bankruptcy estate is irrelevant.
To the extent that the court thought the possibility of a double recovery motivated going to Australia, the court should have understood that Tiber Creek was going to get nothing, let alone a double recovery. And we now know that to be true, that they're going to get nothing. They've gotten nothing. They haven't heard from the administrators since June of 2023. Thank you.
All right, let's hear from the other side here, and Mr. Rees.
Good morning, Your Honors. Stephen Rees on behalf of the appellees. Judge Wilkinson, we agree with you that the district court did not abuse its discretion, or that this is an abuse of discretion standard. And when the district court determined that this is an Australian matter for the Australian courts to decide, that wasn't an abuse of discretion, and this court applies
So
substantial...
can we start there, right? This is an Australian matter for Australian courts to resolve. And that obviously weighs heavily in the public factors as to the local interest. Can you give me any example where a court has dismissed for forum basis, where it is a American contract with two American parties about work done in America to get American government funds, and the court has said that we shouldn't try it here, we should go somewhere else? Is there any such case that you can think of that I should read? Or even a case where like the contract is an American contract between two American companies to do work in America. Any such case where we've said that a domestic company can't come to federal court and get relief? Is there any example?
I can't think of an example at the moment, Your Honor, but what's relevant here is that the judge didn't address this because it's a 12b6 argument, but this isn't a contract between two American companies.
Totally get that argument, right? But we have a district court who's supposed to be making a predictive judgment, right? And so if you're right, if they got the wrong counterparty, the case is dismissed, right? And it's going to be, if they got the wrong counterparty, it's dismissed without any litigation. That's going to impose no convenience problems, right? So if you're right about that argument, then there's certainly no convenience here in America, right? Because the case will be immediately dismissed, right, on a 12b6, right? It only has any convenience issue if you're wrong. And in fact, this is an American company involved with American dealings about American money.
Well, Your Honor, to even determine that point, you would have to look to Australian witnesses and Australian documents. The 2020 letter agreement that is the basis of Tiber Creek 1 is a letter from Tiber Creek.
And wait, just so I understand, you're saying you would have to look to Australian, because Australian company, under your view of the world, came to America and employed an American company to get government dollars. And because they did that, we got to go to Australia to decide whether there was a contract between these two parties? Like they chose to come here, right?
Well,
I mean,
Your Honor-
Illume wanted American dollars.
Whoa, let me hear from counsel, right?
Your Honor, it was Tiber Creek who reached out to Illume in Australia. The 2020 letter agreement is addressed to Illume in Australia. Yes, Illume wanted US dollars and needed a US subsidiary to contract with the US government, but the evidence shows that the 2020 contract that's the basis of Tiber Creek 1 is a letter on Tiber Creek letterhead to a quote-unquote Illume. It doesn't specify Illume Ltd versus USA in Australia. Now,
The CEO of both of these entities was in Australia.
yes, Dr. Parsons is an
It
Australian.
was both limited and USA.
Yes. Then further, our argument is that they didn't sue the correct entity because the contract, this 2020 letter agreement, is with Illume Ltd. And there's several pieces of evidence that support that, including that then in 2022,
But you agree that the district court at the forum stage doesn't resolve that question?
yes, he doesn't need to, but he does look at where are the evidence and where are the documents located that we would need to determine where would be convenient for litigation, where would serve the interests of justice. And not only are the witnesses and documents, with the exception of Tiber Creek in Australia, but as you discussed previously, Tiber Creek injected itself into the Australian bankruptcy proceedings to recover the same amount of money that it then sought in Tiber Creek 1. It injected itself into the Australian proceedings. It was convenient for it to do so. It had agreed to several forum selection clauses dating back to 2014, and then again in 2022, agreeing that Australia is a convenient forum for it to litigate its disputes.
So the 2014 forum selection clause, just to ask a question about it, if I assume that agreement the non-disclosure agreement remains in effect, do you think that forum selection clause governs anything other than the breach of the non-disclosure agreement? So if they published your confidential information, then the 2014 non-disclosure agreement's selection clause would govern, right? But is there a reason to think that it would govern the 2020 agreement that doesn't include a forum selection clause? Do you see what I'm saying? It governs a breach of that agreement, not a breach of any agreement in their relationship heretofore to come. I understand the 22 agreements are different, but I'm just talking about the 2014.
I understand you, Your Honor. And the 2014 agreement, that indicates that as of 2014 at least, Australia was a convenient forum for Tiber Creek to litigate disputes around the breach of the NDA. And it's our position, too, that the 2020 letter agreement incorporated by reference the forum selection clause from that 2014 NDA, and thus any disputes around the 2020 agreement were also governed by that forum selection clause. And then again, Your Honor, there's the 2022 forum selection clauses in the deed of variation and the agreement for services.
Which is the dispute in Tiber 2.
Correct. Well, it's a dispute in Tiber Creek 2 because they say that it was procured by fraud, but it also is highly relevant to Tiber Creek 1 because in those 2022 agreements, the parties agreed that the 2020 agreement was between Tiber Creek and Illume Ltd.
And the question is whether that was fraudulent, right? I mean, that's just a circular piece, right? The whole point is, I got no idea about what really happened, right? Don't take my statements here to be a suggestion of a view on the merits. But the suggestion is Illume put all those in because they understood what was happening here and were trying to defraud Tiber of the money they were entitled to under the agreement, right? And so they understood what was happening. They had good lawyering, and so they, manipulated the system fraudulently to deprive Tiber of its money.
That's their argument, Your Honor, but the witnesses and documents necessary to assess that are in Australia. It's incorrect, as Tiber Creek argued, that all the witnesses for Tiber Creek 1 are located in the United States. Dr. Parsons, who the 2020 letter agreement was addressed to, it was addressed to him in Australia. He's in Australia. And the individuals involved in negotiating...
Are you aware of any instance in which, same question from earlier, but in the fraud context, where a foreign company doing business with an American company defrauds the American company in the process of doing American work, and that's been dismissed for forum grounds? I mean, in all the cases that I've seen, what the courts look at is where are the victims, right? And where was the underlying action taking place? Maybe you want to look at where the fraud took place, but the fraud was directed into the United States. I mean, are you aware of a case where we've said that?
Again, Your Honor, I can't think of a particular case on all fours with that context, but in the motion to dismiss stage, we also raised a 9B argument that fraud hadn't been pled with sufficient particularity, and that there wasn't reasonable reliance, partly because Tiber Creek is a sophisticated entity itself. It's also a government, Mr. Clerucci is a sophisticated government contracts lawyer. And the district court, used its discretion to weigh all these different factors, to weigh, where's the bankruptcy, where are the witnesses?
It didn't really weigh the factors because it said every factor favors you, right? I mean, including the local interest in resolving an American company's dispute with another American company about an American contract to get American dollars. The district court found that factor favors Australia, right? So it didn't weigh the factors. It said all the factors go the other way, which it just strikes me as like an implausible conclusion. And I take Judge Wilkinson's point. We are highly deferential to district courts, right? But there is an abuse of discretion standard, and it doesn't mean that it can never be met. If we adopted a view that we can never overturn a forum case for abuse of discretion, we just wouldn't do the review, right?
Yeah, I think that's correct, Your Honor, that it's not that standard can never be met, but it wasn't met here. And I think it's incorrect to say that the district court...
Let me if I may permit it just a second, my friend. Mm-hmm. I'm interested in who initiated the relationship. There's already between Tiber Creek and Illume. Which one of the parties initiated the whole relationship between the two?
Your Honor, we didn't get into extensive fact discovery here.
So I think what I'm interested in is the degree to which Tiber Creek itself availed itself of the Australian court system and Australian law. We've already pointed to one thing, which is that the Tiber Creek participated in the Australian bankruptcy. Another thing, and correct me if I'm wrong here, but I thought that the parties in their contractual relationship, it's always a question of which contract, that there was a choice of law decision made and that there was a forum selection decision made. And was the choice of law decision made with respect to Australian law and the choice of forum made with respect to an Australian court in the contractual relationships between the parties? So I want to understand the degree to which Tiber Creek availed itself of Australian witnesses or also of Australian law, of an Australian forum, of the Australian bankruptcy. Tell me the degree to which, because your opponent is characterizing this as something where the Australians reaching in and doing this with respect to American companies and everything. The other danger is we can get into a little too much home cooking. And I just want to know to what degree Tiber Creek availed itself of Australian forum and an Australian law, as well as the Australian bankruptcy proceeding.
Yes, Your Honor. So in 2014, the parties had a prior business relationship, and that was between Illum Ltd., the Australian company, and Tiber Creek. There was no Illum USA at the time. That agreement was set forth in a letter agreement that's very similar to the 2020 letter agreement. It looks similar. It's on Tiber Creek letterhead and has a mandatory forum selection clause in Australia. Then there's a 2020 letter agreement, again, addressed to Illum in Australia, addressed to Dr. Sean Parsons in Australia, with, it doesn't specifically mention forum selection clause, but we take the position that it's the 2014 forum selection clause is incorporated by reference. Then in June of 2022, Tiber Creek executes multiple agreements that contain Australian forum selection clauses, and also specify that the 2020 agreement was with Illum Ltd. Then Illum Ltd. Entered voluntary administration at the end of August 2022, and Tiber Creek submitted a proof of debt in October of 2022 in Australia. Tiber Creek submitted a second proof of debt in December 2022. Tiber Creek also voted by proxy in the voluntary administration proceedings in Australia.
What you're telling me is that there were multiple proceedings in Australia that Tiber Creek participated to some degree in, and that there were, you're saying there were multiple agreements executed with a forum selection clause in Australia, law, or an Australian forum, and that there were choice of law provisions in agreements that Tiber Creek executed, because I think that's an important factor, because to the degree that parties choose forum selection clauses and choice of law provisions, they have control over their contractual relationship. And that is likely to counteract to some extent the pure presumption of a plaintiff's choice of forum. You see what I'm saying?
That's correct, Your Honor, and we agree. We think that evidence is really strong evidence that Australia is a convenient forum. And if you look at the district court's opinion, the district court, it's incorrect to say that the district court didn't recognize the heightened deference that's owed to plaintiff's choice of forum. The district court explicitly did, but it nonetheless balanced the different factors here. It noted that there might be inconveniences on both sides, but it nevertheless held that the balance of convenience weighed in favor of Australia, even acknowledging the heightened deference owed to Tiber Creek's choice of forum.
But what you're saying here is that the center of gravity of the parties' relationship could be seen by the district court to be in Australia, and that part of the evidence supporting that are the number of executed agreements with choice of law and forum selection procedures that point to Australia.
Exactly.
Now the response that they're giving to that is, well, yeah, but this was the other set of contracts, and this was with Illum Ltd. and not, or this was with the separation between Illum Ltd. and Illum USA and all the rest, and so we've thrown up with these different contracts and everything. But I wonder if it's not all part of a continuing relationship between Illum in whatever form it is in, and Tiber Creek, and whether by the party's own choice, Australian law and an Australian forum was devised, and the Australian bankruptcy proceeding was one in which they participated. So I'm just concerned about, there might be a little bit of, it might be too much home cooking going along. And I'm also worried about a shell game, given all these different contracts. Could you respond to that?
I mean, we agree, Your Honor, that all those factors, the contractual relationship dating back to 2014 with Illum Ltd., the forum selection clauses that the parties repeatedly agreed to, the participation in the Australian bankruptcy. We also share your concern, Your Honor, that Tiber Creek attempted to jump the line of the Australian voluntary administration proceedings once it realized that it might not recover all that it was owed in the Australian bankruptcy proceedings. It initially injected itself into the Australian bankruptcy proceedings in 2022 against Illum Ltd. For about $9 million. And after a deed of company arrangement was drawn up, partly through Tiber Creek voting by proxy to agree to, when the creditors agreed to enter into this deed of company arrangement that would govern the bankruptcy, that's when Tiber Creek then turned around and sued Illum USA for the same $9 million, trying to recover what it was owed.
Can I ask a question back to Judge Wilkinson's original question as to who initiated the relationship? I thought I heard you say that the original agreement between these two parties was on Tiber's letterhead, but when I look at, and I'm at JA 73, which is the non-disclosure agreement, which I believe is the first agreement between them. That's like an Illum document, right? It's like, I think, fairly evident from the document that that's, Illum's non-disclosure agreement. Are you aware of an agreement before that time, or is that the first agreement that exists?
Your Honor, I would point you to JA 526. It's attached as a declaration to John Clerici, who's the principal for Tiber Creek. That's the 2014 letter agreement between Tiber Creek and Illum Ltd. Again, there was...
And that came after the non-disclosure agreement, which was in November of 2013, which is on page 73?
Yes, that's correct, Your Honor.
What I'm asking is, what's the first agreement, right? The first agreement is the non-disclosure agreement, which is Illum's document. I'm not sure this is crucial. I just want to make sure I understand the first agreement is the one that's about page 73. I just turned to page 600 and something, but right? That's Illum's own document. It's their non-disclosure agreement.
Your Honor, I see I'm out of time. Can I answer the question?
Yeah.
As far as the record is concerned, and acknowledging that we haven't gone into full discovery here, that does appear to be the first agreement, but one party signed in 2013, another party signed in 2014. That's when Dr. Parsons executed it, if you look at JA 076. That's a non-disclosure agreement, and then there's the full letter agreement outlining the scope of work that starts on JA 526.
How is discovery in this case going to proceed? I mean, if we were to reverse the district court, what about all these witnesses that were listed by the district court as being in Australia? Is that part and parcel of another suit, or is the district court going to be able to compel discovery from these witnesses?
Your Honor, our understanding is that in terms of Australian witnesses and Australian documents, the district court won't be able to compel pretrial discovery. There's no subpoena power, and as Australia has signed the Hague Convention, there's no ability to get the sort of pretrial discovery that we would expect in the U.S. And even if this court were to disagree with us and remand, there's still, you mentioned the kind of myriad threshold issues that we want to avoid. There's still many more threshold issues to address. There's our 12b6 argument. There's a personal jurisdiction question with respect to the Australian defendants, Illum Ltd. and Dr. Parsons. There's a potential bankruptcy proceeding under Chapter 15 if the administrators of Illum Ltd.
I'm not sure if we were to reverse, what would we be left? What would we be left with? We're going to be left with a lawsuit that can't go forward.
I think it would be incredibly burdensome to go forward, if at all. As Judge Rushing, you noted the inconvenience on the witnesses, even if they were willing to engage in litigation, is an important factor.
They're going to say, well, no, but you're missing the fact that these are two lawsuits, and this other one can go forward. This is why I continue to be concerned about the shell game, because it does seem to me that basically with whether you're talking about one suit or another, you're talking about basically the same two contracting parties. Are you not?
Yes, Your Honor. Our position is that both cases rely on the same witnesses, the same facts, the same documents, and those witnesses and documents are in Australia.
But wouldn't it be, we talk about convenience, would it not be more convenient to have all of this located in one forum?
We agree, and we believe that the district court properly used its discretion to decide that Australia is the proper forum for that.
Because even if we reversed here, that wouldn't stop the Australian procedures, would it?
That's correct. There's still a liquidation proceeding going on for Loom Ltd., and Tiber Creek has not withdrawn its claim as an unsecured creditor.
So we could find ourselves in a total mess.
Yes, Your Honor, and we believe that the doctrine of forum nonconvenience is designed in part to avoid this sort of mess.
Yeah, I mean, that's what concerns me, is that this could be chaotic, and there'd be more fights here and there over which set of agreements controlled and which entity was involved, which witnesses could be compelled in which suit and which couldn't, and what lies ahead is a mess, and the district court's thinking is that given the choice of law provisions and given the forum selection clauses and given the fact that the Australian administration proceedings are moving forward and given the fact that there are many witnesses, documents, and everything in Australia, that it makes some sense to bring it all together between these two parties and have the same forum separating it out and dealing with this in a holistic fashion rather than in a fragmented fashion that goes across the globe.
We agree, Your Honor, and we believe that that's a very good reason to affirm the district court's ruling.
The thing is, but these are separate suits, and if this one has this is separate. I'm not convinced that all this is all that separate.
And neither was the district court, Your Honor. He consolidated the two cases, and to keep repeating the phrase, all the documents, the witnesses, they're interrelated between the two cases. And yeah, we agree with that position, Your Honor. There are no.
Judge. All right.
Thank you very much.
I want to address a couple of points that you raised, Judge Wilkinson. First thing, there was a question about who initiated the relationship. I don't think that really matters for purposes of forum nonconvenience, but I do want the record to be clear. There was a pre-existing relationship that goes back to 2013, 2014, that time frame. Later in 2020, after COVID shut everything down and the government was looking to find ways to deal with that crisis, the principal of Tiber Creek contacted Dr. Parsons and talked about some of the government funding that was available. You had to, at that time, that particular government funding was only going to American companies. At that point, Illume Limited had already created the Illume USA subsidiary here in the US. And the conversation was to explain that because you have this American company, you can apply for these funds, and that's how they helped.
Why don't we take all of these different agreements, all these different corporate organizations or entities, and have all of the proceedings surrounding the relationship between the parties, the various agreements the parties have signed, the various amendments to the various agreements, the witnesses whose recollections may overlap from one suit to another, why don't we bring them together in a single forum? And that's what the district court, I think, was aiming at, and who wanted the proceedings. He wouldn't know, it would put the district court in one heck of an awkward position to send this part of the case there when there's an overlap between all of these different agreements and amendments and everything. And I think it's hard to parse it all out up here, frankly.
Respectfully, I totally disagree. The Illume Limited is only in the case because it needs to be a party because we're asking to have an amendment declared void ab initio, and we cannot bring that claim unless Illume Limited is in the case. If that case gets moved to Australia, it stops, and we're not looking for money from Illume Limited anyway. There's no reason to throw the baby out with the bathwater, and I don't think there's any reasonable argument that the dispute between two American entities brought in the plaintiff's home forum should go forward in that home forum, but we're letting the tail wag the dog, and I don't even think it matters because nothing is going forward in Australia against Illume Limited. Nothing would go forward in here against Illume Limited if they only would follow the proper procedure and get that bankruptcy recognized, which they still haven't done in the U.S. bankruptcy courts.
That's your projection.
Well,
so I'm just wondering whether it's all going to be as sort of neat and sound and compartmentalized as you would like it.
Your Honor, if I can I want to hit a couple of things. You raised a couple of questions. I want to address them. There's been a reference to forum selection clauses. There are no forum selection clauses. There are clauses that say Tiber Creek cannot challenge Australia. If it gets sued in Australia, it cannot challenge that based on inconvenience. So yes, Tiber Creek waived that if it is sued in Australia. That does not mean everything has to be brought in Australia. It's a non-exclusive forum selection clause, which by its nature contemplates litigation in other places. So that should not weigh one way or the other in a forum non-convenience analysis. There was a question about choice of law. There was no choice of law in the operative 2020.
We also see it quite differently. We're going to throw all this back on the district judge?
The district judge should have addressed this. He should not have dismissed this case. It was an abuse of discretion. I stand by that. It was. I think your own cases, this circuit's own cases, make that, in my view, crystal clear. I don't even think it's a close call. I want to answer your questions.
I would really not want to be the district judge.
I'm sure he was not relishing the thought of dealing with two litigious parties and all of their disputes, but it was his obligation to do so.
Faced with a remand.
Your Honor, I'm running out of time.
What's the choice of law point? Can you make
The choice of law point is that this court, confronted that in the De Federico case itself, and the court stated the need to apply foreign law is not in and of itself a reason to apply the doctrine of forum nonconvenience, and we must guard against an excessive reluctance to undertake the task of deciding foreign law, a chore federal courts must perform often. This court was relying on the Second Circuit for that, but that should not be a reason, and we're talking about whether a contract procured by fraud is void ab initio. There's no difference in the law between here and there.
Excuse me. What should not be a reason? Forum selection clauses shouldn't be a reason.
There's no forum selection clause. The choice of law issue is whether under Australian law that deed of variation is.
You obviously have some differences of opinion about that. The only reason I thought forum selection clauses and choice of law clauses were important is that they allow the parties to control their relationship, and that's part of the whole purpose of the law of contracts. And now you say there was, and you say there wasn't. And they say that that you say there weren't those clauses. They say they were. There's a lot to untangle here.
Well, Your Honor, I see my time is out. If I can just close with two things. First of all, I'm a Philly lawyer. It's been a pleasure to be down here in the Fourth Circuit. in closing, the principle that I think that we get from De Federico is it's not just a standard that the court should apply, but the principle is that an American citizen should not be denied access to courts of the United States except in very rare circumstances. And I submit this is not one of those cases that rises to that level. Thank you very much.
Okay. Thank you. We will come down and greet counsel. I'll ask you all to come up, then we'll proceed into our last case. Yeah, pleasure to have you here. All right. When you're ready, we will begin with Fitzgerald versus Botetourt County when the attorneys are ready.
Comfort break, Your Honor.
What's that?
I think my colleague had to run down the hall for a comfort break.
Would the courtroom deputy please report on their presence and suggest that it might be a good thing if they were present for their argument? Who are you representing?
Botetourt.
You're representing Botetourt?
Yes.
You all please be seated.
I apologize. I had to use the restroom. I apologize. I am ready to go.
All right, Mr. Strelka, we're pleased to hear from you, sir.
Yes, may it please the court, thank you for your patience. My name is Tommy Strelka from Virginia Employment Law. I'm here on behalf of the appellant, Clay Fitzgerald, whose case under the Age Discrimination in Employment Act was dismissed on summary judgment in the Western District of Virginia. I've been in front of all of y'all judges before. It's good to see you again. I'll state that in about 20 years of employment law, this case is not ultimately legally complicated. It does have some facts, and it's our contention that the court, and on a de novo review here today, that the trial court misinterpreted those facts. And this is a retaliation case. This is not an age discrimination case. This is one count of retaliation based upon protected activities, not protected classes. This is an individual, a battalion chief, Mr. Fitzgerald, who had made repeated protected activities, it's undisputed, under the Age Act throughout the years that he was there. The most recent was July of 2017. A month after that, in August of 2017, the county administrator, his name is spelled Gary LaRue, but it's pronounced LaRue. Mr. LaRue directed that he be disciplined at that time. Thereafter, he was terminated in May of 2018, and the parties, along with the court, seemed to agree that, if you want to put a alleged but-for reason for why he was terminated, it was this issue with the purchase and procurement of a brush truck. A brush truck is a off-wheel, off-road capable vehicle. It looks like a pickup truck with fire suppressant tech mounted on the back. It's not as big as a fire truck, as a full-size fire truck, but it's something In Botetourt County, you can drive over the fields and the ground to put out brush fires. That's the whole point of it. Mr. Fitzgerald, the appellant, had been directed previously by Gary LaRue that he was not to be involved in ambulance purchases. That's at 259 in the record.
His previous job was as a salesman for an ambulance company.
Sure.
Kind of suggests it might be a little conflict for him to be purchasing brush trucks from, given his previous employment.
Well, with all due respect, Your Honor, a brush truck is not an ambulance.
What?
A brush truck is not an ambulance. It was, I believe it's in the record, the company from which that this was procured was not the company that Mr. Fitzgerald had worked for. And he had worked on other procurements of other vehicles, non-ambulance related in the past. The evidence also shows that this particular brush truck, which was identified for a volunteer fire department by the name of Glenn Wilton, had been set in pace by Chief Britt. This was something that the chief at the time had done the heavy lifting to get the ball rolling on this procurement. He had made, there are communications in the record where he had discussed specifications. He picked the Ford chassis, and
Just kind of downgraded the requirement about authorization as just a mere formality or something that's not really all that important.
well,
Because you didn't have any written authorization.
but he doesn't need it, not under the policy.
I know, but perhaps. But you seem to make light of the authorization requirement, that it wasn't that big a deal.
I don't make light of it, Your Honor. This was something that, well, first, the court needs to recognize, and I think this is important, Chief Britt left. He resigned in late November, and this procurement was set in motion by him before he left. And then on November 20th, Gary LaRue has a meeting with the appellant in which he states that the volunteer fire departments are to be taken care of. We need to support them.
Can I ask a framework question? I know
Sure.
you said this is mostly a fact case, and that might be right, but a framework question. Hypothetically, if I disagreed with you and I thought the policy required express written authorization, notarized and like filed with a court, whatever, something crazy, right? But it required that and he didn't do it, right? So if he was required to get authorization and he didn't do it, as I understand your argument, that resolves the case, right? That would, in that scenario, from your perspective, there might have been other arguments, but that your argument would fall then.
Correct.
And so we really just fundamentally are called to decide that question.
That's absolutely right.
Not some other, if he was required to get approval, that there was some other thing going on. It's that question.
In the light most favorable to the appellant.
No, I totally understand that. But there's not another issue. It's just that's the fundamental question.
That's
if he
it.
had authority. Okay, so what about if I were to find that he did not need authority, but the fire department reasonably believed that he did? So they were reasonable, even if mistaken, in believing that he was required to get it. I'm not saying I get there on these facts.
I like that. I like the thought.
Right?
Yeah.
And so, because we often say that...
I can poke holes in it, though.
Right. We often say that, if I fire somebody because I believe that they stole money, and it turns out, like, forensics later reveal that I was wrong, right? That's not pretext, right?
Correct.
Because I believe that you stole the money.
Absolutely right.
And so as long as that belief was reasonable, we would affirm that sort of legitimate reason for firing. And so does the same idea apply here?
Yeah, it does.
If hypothetically, based on these facts, I found that the fire department reasonably, but as it turns out incorrectly, believed that the policy required authorization.
How could it be reasonable when they feign surprise
Don't
at
fight.
the end?
Don't fight the hypothetical. I'm asking the legal question.
Well, the this is a factual.
I'm saying accept as a premise
Okay.
that I made that find. I'm not
Okay.
making either of these findings.
All
I want to understand the legal framework.
Sure, Your Honor. And I'll go out with you right where you are,
Yeah.
okay? If this court were to believe, despite the evidence I'm about to talk about,
Yep.
that this administration, this county, was justifiable in their belief that it was reasonable that he did not have authority and he was off running and gunning for the first time in his 30-year fireman career,
Yep.
you're right. You're right. Then it's a justifiable, and we can't prove pretext. It's gone.
Okay.
You're
I
right.
just wanted to understand your argument.
Yeah.
And I'm happy to hear from you on the facts.
Yeah.
I just want to understand what the framework we've got to fit into.
Right. Well, the facts are that there's multiple communications between the Deputy Chief Ferguson, Susan Tincher, Gary LaRue, all of these individuals in the months leading up to his termination. And at that time, they clutch their pearls and they feign great surprise. This completely unaware purchase has somehow fallen into the Glen Wilton parking lot. How did this occur? How did it occur? You were copied the whole time.
Can I ask you a follow-up question?
Absolutely.
To the framework? I had thought maybe you were going to say the district court's framework was wrong, that the question is not whether he was authorized to buy the truck. But you seem to have now agreed with Judge Richardson that doesn't solve it. You have to show that they didn't actually have that reason.
Right.
That wasn't actually supporting, but also that the real reason was retaliation. So can you tell me what's your best evidence that the real reason was retaliation?
Right, because if we can prove pretext, if we can prove, the question is whether defendant had a legitimate, non-discriminatory reason to terminate plaintiff. If we can prove that that reason that they have cited, the purchase with the brush truck, is non-legitimate, then we have proven pretext. And then the case has satisfied the prima facie elements of retaliation, and we are, the case must be reversed.
I see that in response to Judge Rushing's question. I didn't see in this record the idea that the real reason was retaliation. I just thought that the record indicates that there was a big kerfluffle over authorization and the like, but
Sure.
the policy is clear that authorization is required, and you can understand the policy, the county's concern about that, because they really don't want a whole lot of people running around exercising purchasing responsibility. He says he can do it, another employee says they can do it, another employee says they can do it, and pretty soon the policy was in shreds. And as I read the record, whether they were right or wrong, they were concerned about employees making substantial purchases without authorization.
I mean, that, Your Honor, I think you're assuming that's what they have said, but that's not what the evidence says.
Right, but I didn't see anything to follow up on what Judge Rushing said. I didn't see anything to indicate that this was a retaliation.
Sure. This is an individual who made repeated protected activities over the years, up into 2017, when the most recent, he's received discipline from Gary LaRue the next month. The decision maker was also Gary LaRue.
But that's pretty much of a double-edged sword.
Right. He doesn't have any disciplinary actions. He doesn't have a history of work performance issues.
Counsel? Proceed.
Sorry, Your Honor. The evidence in the record of this case is this is a firefighter with years of excellent work performance. And this is a firefighter who made protected activities under the law, specifically to the decision maker who made the decision to terminate him. He made a protected activity under the law. 1 month later, that decision maker chose to discipline him for it, which the court has indicated that the other issues were questions of fact.
You said these activities occurred over a number of years.
Yes, Your Honor.
And yet there was no action taken over a number of years, despite the fact
There was.
that no, there wasn't any, not the action, the adverse action that you complained at. The record indicates that the company was concerned with its policy, and this is we're talking about a $40,000 purchase without authorization and without whether the company believes, whether rightly or wrongly, it was without authorization. And that leads to a chaotic situation within the workplace if other people are making substantial outlays of federal funds, of county funds, without any kind of authorization. It just there's every reason in the world for the county to be concerned about what's going on.
Chief Britt authorized the sale
Not a
of the truck.
chimerical, it's not a fantastical concern.
Chief Britt procured the sale of the truck, Your Honor. The appellant followed through on that. Section 102 of the purchasing policy provides that the administration may, quote, delegate the purchasing responsibility to a responsible subordinate. In his testimony, Gary LaRue said that the purchase of a vehicle would be up to Chief Britt and those lower than him on the chain of command. All of that sets into play that the appellant in this case was authorized to make this purchase. He had never been told no. And the individuals who were aware of this the entire way through, including Ferguson, the documents in the case, their names are all over this. They feigned surprise.
He'd been told no, he'd never been told yes.
He had been told to take care of the voluntary departments. He'd been told by Chief Britt. He was copied on the emails from Chief Britt in which Chief Britt is picking the vehicle specifications. Susan Tincher is the purchasing agent under Section 1.2. She signed the purchasing order. She authorized it. The appellant did his job, Your Honor. That's all he ever did. This is an individual who made repeated protected complaints, and Gary LaRue seized upon it and used this to terminate him. He did not have an adverse employment action prior to this, but in the record of the case is replete with instances of him getting disfavorable positions, not being able to ride the truck, ride the engine as it were. There was a number of issues that were cited by the plaintiff in which it was leading to try to make him quit, try to get him out of this fire department because of his protected activities. And so this situation was leapt upon by the appellee to wrongfully fire, and the facts do not justify it.
All right.
Thank you, Your Honor.
Do you have any questions, Judge? Do you have any questions? We have no questions. Mr. Gwynn?
Afternoon, Your Honor. May it please the court, my name is Jim Gwynn, and I'm here on behalf of Botetourt County. May we all be discriminated as much against as Mr. Fitzgerald was? He was promoted he started at a rather low level all the way to battalion chief. In 2017, Gary LaRue, who's accused of all these employment atrocities by the plaintiff, promoted him to battalion chief, Your Honor.
Is there any evidence that LaRue, in April of 17, when he pushed for his promotion, that LaRue knew of the plaintiff's complaints about age discrimination?
I think he knew about the one in 2017, Your Honor. I know that he addressed that one.
Couldn't have known about that because I'm asking about in April of 2017, right? That's when the plaintiff was promoted.
Yes.
And he was promoted by LaRue.
Right.
Or LaRue was involved in his promotion, right? In June of 2017, the plaintiff complains about discrimination. So he couldn't have known about that one yet because it hadn't occurred.
Correct.
Right? What I'm asking is there any reason to think that LaRue, when he pushed for promotion, that he knew about any of the plaintiff's prior complaints, right? Because we know there are old complaints that were made, right? And so what I'm asking is there any reason to think that LaRue knew of those things?
There hasn't been any evidence of that, Your Honor. He was not the county administrator at the time, as Guzzi was.
So why is it relevant to consider whether LaRue appointed or promoted the plaintiff at a time when he did not know about age complaints, and then allegedly retaliated after the first time he became aware of age complaints in June of 2017. Right? So those things have now changed. The theory would be he liked him when he wasn't a complainer, right? He complains in June of 17, and by August of 17, he's flipped on him, and he now is discriminating against him or retaliating more precisely.
It's the application, Your Honor, of the Proud case, and that is that he was hired by Botetourt County. He was over 40, so he was already in the protected class. There is, according to that decision and according to this court...
That's totally fair if he's over 40, right? Because that's something he can't change, right? But that's a discrimination case, right? So you're black or you're not black, right? You're old or you're not old, right? And so that thread runs through. But here, when he was promoted, the promoter, Mr. LaRue, didn't know he was a complainer, right?
But he knew his age.
But we don't have a discrimination case here, right? We have a retaliation case.
I think it applies in a retaliation case. From the standpoint of how you analyze whether or not there was a discriminatory intent at the time, which I think was Judge Rushing's question about whether or not there's a discriminatory intent at the time that he was terminated.
But the point here is that the presumption you're relying on is a presumption that makes sense in a immutable characteristics case, right?
Sure.
It's hard to see how someone could be accused of being biased against a certain ethnicity if they hired a person of that ethnicity. But that same presumption doesn't carry over when I hire someone not knowing that they are in the future going to make complaints, but then I fire them later because I don't like the fact that they made complaints. Do you see the point here? That presumption,
I do, and I
that
apologize.
presumption
I didn't
makes
understand
sense
what
in
you're
Proud, but it doesn't make sense in retaliation.
I could just get Judge Rushing to explain my thoughts more often. I would be so much better off.
I think they call it womansplaining.
Right.
I've got an office.
I need it.
that
I need
to do that with. From that standpoint, the evidence in this case clearly shows, though, that that Mr. Fitzgerald was not approved and not been authorized to engage in this transaction. On November 22nd of 2017, he sent an email saying that all we need is the go-ahead. He clearly knew at that time that he didn't have the go-ahead. He then, on December 8th of 2017...
Do you agree with your colleague? Do you agree with the framework we have here that if your client correctly or reasonably believed that approval was required, then he seems to agree he can't show pretext. That might not be true in every case, but in this case, that's the framework we're operating under?
Yes, Your Honor. I mean, it's clearly the case that was the motivating factor from the standpoint of Mr. LaRue, was that in addition to some other instances that he was unhappy with, that the main one, and I think that, and I understand why Mr. Fitzgerald's trying to downplay this one, but the main one was the fact that he made a $37,500 purchase without authorization. And as Judge Wilkinson said, in a county where you have to account to the public for your spending.
I mean, the evidence the record is replete with evidence that this policy mattered to the company. They have a policy. The policy is not ambiguous. It's set out. The authorization requirement is not ambiguous. It's set forth. There's all sorts of evidence of concern about unauthorized purchases. Every county and every local government that I know of wants to keep some kind of control over its finances and over its financial records. And there's just not, this is actually central to local governments, that there be no question about unauthorized purchases, because you can get in deep trouble in a real hurry if if employees get the idea that no particular authorization is required, and you do away with bidding, and you allow all sorts of friends and neighbors purchases, and you all have all sorts of individuals making purchases with kickbacks and the right. It's just fundamental to the integrity of local government that they keep control of this. And the record indicates that's what was on their minds.
And I would submit, Your Honor, that comes from the top down, from the Commonwealth, that the Virginia Public Procurement Act demands that there be this plan and policy in place. And in our policy, we specifically say that the county administrator is designated the purchasing agent and shall serve as the principal public purchasing official for the county, and that it involves all purchases. So she is responsible for all purchases that the county makes. And yes, can you designate, can you authorize? Sure, but that hadn't been done in this case.
The newspapers are full of articles about people having unauthorized purchases and compromised bidding practices and under the table contracting and all the rest. And as I say, I have never seen or read about a local government that wasn't really sensitive and concerned about the problem of unauthorized purchases. And if the policy were ambiguous, that might be one thing. If there was no such policy, there might be another thing. But, you know, they $40,000 going out the window without authorization, that's, you know, that's not pocket change.
No, not in a place like Botetourt. You know, we're not talking about.
Chief Britt had the authority to make the purchase, right? So the policy allows the county administrator to delegate authority, and there seems to be some evidence in the record that the chief had that authority to make small purchases, which is defined as less than $50,000, as I understand it. So before, I understand he wasn't there anymore, but before he left, do you think he could have approved this purchase?
No, Your Honor. I think what he
Why
would have
not?
done, he had not been authorized to make it. I think what he would have done is he would have gone and reported to the county administrator and said, okay, we've looked at the 3 different types of trucks. I've run it by the Glenn Wilton chief. The Glenn Wilton chief agrees with me. The Ford is the one we want. We'd like to get the Ford. And at that point, the county administrator would say, go get the Ford. And then he would be authorized to buy it. And that's how that would work.
So in your view, in the county, approval only happens on the back end, right? The last step is approval. It's not on the front end when the administrator says, all right, this particular station house needs a bus truck, go get it.
Exactly, because we don't know what it costs at the front end, and we're just simply not going to give people that carte blanche to go out and spend the county's money. We have to know what the expense is before we're going to do it. It was in the budget. We had to make sure that it met the budget. And the fact that it's in the budget doesn't mean that it necessarily is going to get spent or when it's going to be spent. And there are going to be times, again, in a county the size of Botetourt, where maybe this month we don't want to spend it. Maybe we're going to wait a month or two and we'll spend the $37,500 next month because of another expense that we've got coming up. So there are a number of different things that go on there. I'm confident that this is not the way it works in places like Loudoun or Arlington or Fairfax counties from a purchasing standpoint. I don't think that the county administrator there is as concerned with $30,000 or $40,000 as the county administrator is in Botetourt. But at the same time, they both share the same ethical and good government concern to make sure that only authorized purchases are made. And under these circumstances, Mr. Fitzgerald admitted as much in November when he said, as soon as the go-ahead is given, he didn't have it. He knew he didn't have it. We don't know what possessed him to go and buy the truck. But to now say, as they argue, that that the county is feigning surprise. Well, yeah, they were all surprised. They knew that there was a budget, a truck in the budget. They knew they were going to get a truck, but they were really surprised the day it showed up because they hadn't authorized anybody to buy it yet. So yes, that particular part of it, they were surprised about. Not the fact that by the, sometime in that fiscal year that there was going to be a brush truck there, but rather the fact that it showed up the day it showed up when nobody had signed any authorization and nobody had signed the go-ahead for it. And that's the whole key to this, is the evidence and what frankly motivated the district court judge was, or magistrate judge at the time, now district court judge, was that email where he said we need the go-ahead, and then he couldn't produce a single shred of evidence, and still has not, that he had the go-ahead, which was essentially the authorization. And so I would submit to the court that under these circumstances, that they failed to show pretext because the county had either, they knew that he had not had approval or they reasonably believed it, and it was not something that was picayune or anything else. I mean, the bottom line is this is a very, very important component to the way the county operates from a financial standpoint. So if there aren't any other questions.
Well, hold on. Do you have any more? We have no further questions.
Thank you.
Mr. Strelka?
Yes, thank you, Your Honor. So in this case, the appellant testified in the record. I just had it up here, and of course, as I moved from my station up to here, I lost it. Regarding his communications with Chief Deputy Ferguson, who was above the appellant in the chain of command. There were several points during this process via email and in person. I asked Chief Ferguson to confirm the funds were there to complete the purchase with those budget lines, and if there was anything I was missing, as he has the better working knowledge of the administrative side of things than the rest of us. This was an individual who went to his supervisor at the time and discussed over email and in person the procurement of this truck. And this supervisor signed off on it. The supervisor also never made a protected activity under the age statute. Supervisor is still employed. Susan Tincher also signed off on this. Susan Tincher never made a protected activity under the age statute. She is still employed. The evidence in the case is that Chief Britt authorized this. As the appellant testified, he said that this was something Britt put in motion and the bid process was done by him through purchasing before he left. The funds came from the non-spent DFP money. I inherited the project that was already in motion along with another generator that was already to be purchased when I became their contact. That was in an email that the plaintiff had sent to Gary LaRue prior to his termination. The evidence is that the individuals involved, perhaps through their own neglect or negligence and not being on top of every communication after a chief of the fire department resigned. That's an easy explanation, okay? But at the end of the day, they were still copied on absolutely everything. They had noticed that this purchase was actually happening. And all of those individuals who also signed off on it, who never said no, who over 6 months of working with him to get the brush truck, they were not fired. So with that, I thank you all for your time. It's been a long day. Y'all have been here all morning. I appreciate the time you've given to this case. I do. Do you have any other questions? I'd be happy to answer them.
All right, sir, we thank you.
Thank you.
Thank you. Thank you both. We will come up and we'll adjourn court and come on up and shake hands. Or they'll come down and shake hands and then come on up.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.